Good morning. My name is Felicia Orth, hearing officer appointed by the Environmental Improvement Board to conduct a hearing in a rulemaking on the Clean Transportation Fuel Program.
Betty, if you can go on to the English or onto the Spanish panel, please.
Yeah. Ms. O'Grady, would you please share about the Spanish channel?
Good morning, everyone. For those who are here present in the auditorium, if there's anybody that would like to listen in Spanish, please let me know and I'll bring you a headset. Para alguien que está aquí presente en el auditorio que quisiera escuchar la interpretación al español, por favor, avísenme y yo les traigo los auriculares. For anyone who is on the WebEx platform, if you would like to access the simultaneous interpretation of the proceedings, if you go to the lower left-hand side of your screen, you'll see a globe. Click on the globe and then click on Spanish, and you'll be able to listen to the simultaneous interpretation. And you can also adjust how much of the English and Spanish that you hear by adjusting the sliding bar. Y para alguien que esté en la plataforma de WebEx y que quisiera escuchar la interpretación simultánea, por favor, miren en la esquina inferior a la izquierda y ahí verá el globo. Y ahí puede hacer el clic y escoger español. También puede deslizar la barrita para escoger o decidir cuánto quiere escuchar en inglés y cuánto quiere escuchar en español. Thank you. Gracias.
Thank you, Ms. O'Grady. So while we're talking about devices and technology, please, if you have a cell phone on you, reach for it and mute it. If you have a computer with you, please mute it. Otherwise, it will interfere with the computer system we have here. We have just a few preliminary things. I thought yesterday was really lovely. Just a really lovely day yesterday of hearing some good evidence. And then last night, I think the British call it a cock-up. We muddled our very attempts to try to assure that we could have a public comment session in the evening, that we would not be precluded from having a live link at 6 when we shut down all the equipment here and drove 5 miles up the road. Meant that people were misled and went to the daytime link instead of the nighttime link that had been especially set up. So there were only about 6 of us on the nighttime link, no public commenters. I apologize to the board members who were saying, "Where are you?" I know there was Climate Change Bureau staff and council trying to get on, probably potential public commenters, and I'm very, very sorry. I think we learned something, even though we learned it the hard way, having one link and just leaving that live somehow with a co-host or some other way for both the daytime and evening sessions. For the other 2 evening public comment sessions will be the way to go. So we're going to take down those extra misleading links. Again, I'm very sorry. Let's see. Just a few reminders. I know that the chairs here, if you don't have a table with you, can be awkward, but if you're counsel making an objection, for example, from the back part of the room, please come to a microphone. Otherwise, you're not picked up for the folks on the platform. And any witness or counsel even who are reading something, we humans tend to speed up when we read. So I'll just ask you keep it nice and slow for the court reporter, for the interpreters and the rest of us. And let's see, Mr. Noya, you said you had a preliminary matter you wanted to raise.
Thank you, Madam Hearing Officer. Graham Noyes appearing on behalf of Infinium, Verity Clean Fuels, and the SAF producers, GEVO, NXT, and World Energy. The specific issue is typically in the testimony we're seeing that a foundation is laid for a witness. In all three situations where I'm representing clients, I'm on the witness list there. And so I'd like co-counsel Ann Menard to lay the foundation with me. Unfortunately, she teaches on Thursday, which is when the expected testimony would happen. So I wanted to request to see if we could take just those foundations out of order, perhaps tomorrow morning or end of the day tomorrow. And I'm not requesting anyone waive any objections to my testimony, but just to establish the foundations. Thank you.
Right. I'm certain we can find a good time to do that with you.
Thank you.
Are there any other preliminary matters? No? Well, then we will resume with the department's case. Ms. Sona.
Good morning, everybody. So where we left off yesterday, you had heard from Colt Vaughn, who skillfully coordinated and guided the work to get us here to this hearing. You heard from Claudia Borchert, the bureau chief, who has been leading a fast-paced and cutting-edge team. You heard from Dr. Angela Rasso, who explains the more technical ins and outs of the rule and expectations of the regulated parties. And now we have with us this morning Dr. Colin Murphy. So thank you, Mr. Murphy, for joining us. We know you had a very hectic travel afternoon, evening, got into Santa Fe very late last night. So if we could be kind to a perhaps tired Dr. Murphy, that would be appreciated. Also, Dr. Rasso had a very long night with a sick child. So if we could be kind to her and her questions.
All right. Dr. Murphy, would you please spell your first and last name?
Sure. Colin Murphy, first name's Colin, last name Murphy.
Thank you. Do you swear or affirm to tell the truth?
I do. I feel like I'm getting a little feedback in the mic.
Yeah, let's trade.
Okay.
Make sure they're both turned off. Okay.
Yeah, that seems a bit better.
Thank you. And Dr. Murphy, it does seem perhaps like you're shouting into the microphone, but it does not come across loud in the room. So if it feels like you're loud, it ends up being quieter through the speakers.
Okay.
Dr. Murphy, can you share with us where you're employed?
I am employed at the University of California, Davis Institute of Transportation Studies.
And what services do you provide for the UC Davis Institute of Transportation Studies Energy Futures Research Program?
So I am the co-director of the Energy Futures Research Program. It is this is the arm of the ITS Davis that focuses on energy systems and related policies. I lead most of our work on alternative fuel technology and policy. I also direct the Biofuel Land Use Change Research Program. Biofuel Land Use Change Research Program, which surprisingly enough looks at the impacts of biofuels on land.
And how long have you worked for UC Davis?
In this position, I have been at UC Davis for almost 7 years.
Have you had any other roles with UC Davis before this position?
I received my PhD from ITS Davis in 2013. I also have an undergraduate degree from UC Davis from the 2000s, from quite a while ago.
Thank you. You shared with us a little bit about what you do with the research program. Is there anything else you'd like to add about your role and what you do?
So ITS Davis has a long history of doing sustainable transportation research and has been particularly connected to low carbon fuel standards, like the one being proposed here for the Clean Transportation Fuel Standard. The founding director of ITS Davis, Dan Sperling, is one of the Dan Sperling, Sperling. He was one of my advisors in graduate school, and he is essentially one of the co-creators of the low carbon fuel standard. Did a lot of the foundational work to develop the basic structure and do the research to justify it, and then sat on the California Air Resources Board for 16 years, where he helped shepherd it through its initial implementation and deployment. So we have been really the leading source of academic research on the topic, I think, since its inception.
Thank you, Dr. Murphy. Can you very briefly share with us the topic of your doctoral dissertation?
It was focused on evaluating the environmental impacts of advanced biofuel production using life cycle analysis, with also some elements of air quality analysis.
Have you published any articles or research papers in the field?
Yes, I've published over 20 peer-reviewed articles or technical reports on issues related to sustainable transportation, alternative fuel policy, alternative fuel technology, life cycle analysis, as well as a handful of papers on other topics.
And are these papers and articles and reports peer-reviewed and published in academic journals?
Many of them are published as technical reports through the Institute of Transportation Studies or other related entities. The level of peer review varies, but certainly all of the 10 to 15 journal articles went through peer review, and most of the technical reports through ITS Davis also went through peer review.
And in your role researching low carbon fuel programs, have you presented at academic conferences and seminars?
Yes, many times.
Are some of your publications included in the record for this rulemaking by both NMED and other parties?
Yes, they are.
Is NMED Exhibit 13 a copy of your resume?
I believe so.
The next tab.
Yes, it is.
And is the exhibit prior, NMED Exhibit 12, a copy of your written narrative testimony?
Yes, it is.
Do you have any corrections that you'd like to make to that written narrative testimony?
No.
Do you adopt NMED Exhibit 12 as your testimony today?
Yes, I do.
And have you prepared a oral summary of that testimony?
Yes, I have.
Okay, please go ahead and share that with the board and the parties.
Hello, my name is Colin Murphy. I am the co-director of the Energy Futures Research Program at the University of California, Davis Institute of Transportation Studies, where I lead our work on alternative fuel policy. I am also the director of the Biofuel Land Use Change Program, which evaluates... Slow down. Oh, sure. Okay. Okay. I am also the director of the Biofuel Land Use Change Program, which evaluates how biofuel production affects land use. The UC Davis Institute of Transportation Studies, which I will abbreviate as ITS Davis, is the largest university research group focused on sustainable transportation in the US and likely the world. We have around 200 researchers, students, faculty, and staff at any given time, and have produced cutting-edge research topics ranging from electric vehicles, urban design, public transit, freight, automated vehicles, renewable fuels, and more. I received my PhD from ITS Davis in 2013. Most of my work at that time was focused on assessing the environmental impacts of biofuel production technologies, Since then, I've worked as a science policy advisor in the California legislature, as well as a researcher and advocate for an environmental nonprofit. I'm here to speak with you because researching, modeling, and speaking about policies like the Clean Transportation Fuel Program that is under consideration here in New Mexico has been the primary focus of my work for over a decade. I'm here to help convey not only the science behind these programs, but the history of them, and discuss how they've impacted the states that have adopted them. Each state is different, and that diversity is reflected in small design differences as well as variations in outcomes. Despite this, we have observed many common themes and occurrences across programs, and that gives us some evidence on which to base forecasts of how the CTFP will perform in New Mexico. My experience in this field has also identified areas of particular complexity that deserve a deeper conversation. I am happy to answer any questions you have about programs like these. However, I will defer questions about details of the CTFP to New Mexico staff. In the interest of full transparency, I want to disclose that my colleagues and I at ITS Davis are under contract to the New Mexico Department of the Environment to provide technical assistance related to the design and implementation of programs like CTFP. I have no other competing financial interests. I hold no stock, ownership stake, or paid positions with any companies that would be subject to or would benefit from the CTFP. My ITS Davis colleagues and I are bound by professional and ethical obligations to provide evidence-based, unbiased guidance to support the public interest. All of this is to say, I am here as an independent expert on topics related to programs like the CTFP, and I have no vested interest in supporting a particular outcome, except that as a human being and a parent to a 10-year-old son, I want to see a stable climate for current and future generations. New Mexico's CTFP is largely based on a type of program commonly called a Clean Fuel Standard or a Low Carbon Fuel Standard, abbreviated as LCFS, though the name varies across the various jurisdictions that have implemented it. The first LCFS programs were implemented in California and British Columbia in 2010. Oregon implemented their own version. Sure, okay, sorry. So implemented in California and British Columbia in 2010. Oregon implemented their own version called the Clean Fuel Program in 2016. Brazil's Renova Bio began in 2017. Washington followed with their Clean Fuel Standard in January 2023, and Canada began enforcement of their clean fuel regulations later that year. All of these programs share the same core mechanism. They focus on the carbon intensity of transportation fuels, the amount of carbon emitted across the fuel's full life cycle for every unit of energy delivered to the vehicle. The program sets a target for the average carbon intensity of all transportation fuels in a given jurisdiction. This target declines over time, creating constant but gradual pressure for fuel suppliers to reduce emissions. Producers and distributors of high carbon fuels like petroleum, gasoline, or diesel generate deficits that quantify the GHG emissions in excess of that year's target. Low carbon fuel producers and distributors generate credits representing emissions reductions beyond the requirements of that year's target. Entities holding deficits must produce or purchase enough credits to match the number of deficits they hold at the end of a compliance period, which is typically 1 year. High carbon fuel producers and distributors must either invest in credit generation or carbon intensity reduction within their own business, or buy credits from low carbon fuel producers. Either way, financial resources flow towards lower emitting fuels to help them compete against incumbent fossil fuels. Clean fuel standards like the CTFP play a critical role in efforts to avert the worst impacts of climate change and reduce the environmental impacts of transportation. While there are many technologies and policies that can contribute to this effort, extensive research has made it abundantly clear that no single technology or approach can reach this goal alone. We know that electric vehicles are going to be critical in this effort, but they cannot serve all transportation needs, and it will take decades to expand production and then wait for the fleet of vehicles to fully turn over. We know there are other technologies like biofuels that have entered the market at scale and can displace fossil fuels with lower emitting alternatives, though their production potential is probably limited by the amount of agricultural land we can commit to this purpose.
You've sped up again.
It's a habit, I'm very sorry. There's a lot to cover. To accurately assess the environmental impacts of fuels, you have to look beyond just the tailpipe and consider their full life cycle, including producing raw materials for feedstock, converting those into a fuel, bringing it to market, and the impacts of any wastes or byproducts that may be generated. An effective fuel policy for today's challenges must put many dissimilar fuels onto a level playing field and consider the full impact of each. Clean fuel standards like the CTFP do just that. They establish a framework that incentivizes a wide range of fuels in proportion to the greenhouse gas benefits they provide. Programs like the CTFP consider impacts across a fuel's full life cycle and flexibly adapt to rapidly changing technologies and markets. They support investment into critically needed clean energy technologies and leverage the power of market competition to allow regulated parties to find the lowest cost options to achieve the program's goals. This is not to say they are a silver bullet or capable of single-handedly solving the problem of climate change. Transportation fuels are only one part of a very large problem. But I have spent more than a decade working on how to decarbonize transportation, and I have yet to see a clearly superior substitute for life cycle-based fuel carbon intensity standards like the CTFP. While no policy is perfect, the preponderance of evidence suggests they have been generally effective. This view is reinforced by the fact that we now have 15 years of operational experience with programs like these, and an ever-increasing number of jurisdictions around the world have considered this issue and adopted similar policies. Over the last 2 years, at least a half a dozen states have introduced legislation or taken some other formal step towards adopting a clean fuel standard of their own. While programs like the CTFP are effective at achieving their goal, they are also complex. I won't try to cover all possible aspects of these programs in my opening statement. Instead, I'll focus on answering questions and clarifying areas where you would like to know more. There are, however, a few particularly complex and heavily discussed topics I want to mention briefly before we move into the discussion. The topic first on many people's minds about these programs is cost. Gas prices are already a burden for many people, and there is concern that programs like CTFP could make it worse. The experience of jurisdictions like California and British Columbia suggests that these costs are generally low. In the early years of the program, they may be nearly zero. Even today, with California's program having reduced carbon intensity of transportation fuels by more than 20%, the impacts on gas prices are smaller than the normal seasonal variation in gas prices, or the amount by which prices increase when there is a geopolitical disruption in oil markets. As time goes by and targets become more strict, costs in high carbon fuels will increase, but at the same time, the amount of petroleum used, and therefore the number of people who are subject to any program-related price increases, will go down. As gasoline demand declines, the laws of supply and demand suggest that the price will go down too. Breaking the historical near monopoly of petroleum on transportation fuel will allow competitive pressures to further drive down costs. In addition, there have been numerous studies on the costs and benefits of clean transportation fuels, and a strong preponderance of evidence suggests that the benefits of improved air quality, slowing climate change, and supporting innovative sustainable technologies outweigh the costs of the program. It is quite clear that the impacts of climate change are going to impose severe economic costs on virtually everyone, but they are likely to be worse for vulnerable, lower-income populations. Any discussion of the costs of a climate program must also consider the costs of inaction. It's important to recognize that programs like the CTFP are revenue neutral to a state's transportation system, apart from administrative costs, which are minor when compared to the size of the transportation fuel market. What this means is, unlike a tax, all revenue that flows through the CTFP market stays within the transportation fuel sector. High carbon fuels purchase credits, which sends revenue to lower carbon fuels. Money is not siphoned off for other government priorities. The last thing I want to say about costs is that market-based mechanisms, like the one at the core of the CTFP, are a gold standard method for limiting costs in environmental policies. These market-based mechanisms allow regulated parties a lot of flexibility to find the lowest cost route to compliance, and the evidence suggests that they have effectively done so in the states that have already adopted similar policies. Next, I want to discuss the air quality impacts of cleaner fuels. The fact that fossil fuel combustion results in the emissions of many harmful air pollutants, most notably particulate matter and ozone precursors, has been clearly established by decades of scientific study. Insofar as programs like the CTFP tend to reduce fossil fuel combustion in favor of cleaner alternatives, they are very likely to lead to measurable improvements in air quality. In 2022, I was part of a team that used advanced computational simulations of the atmospheric behavior of air pollutants to project the impacts of an expanded clean fuels program and other clean transportation policies in Oregon. In addition to the expected air quality improvement across virtually every part of the state, we saw a narrowing of disparities between the communities most impacted by air pollution, which were largely lower income and non-white, and those least impacted. That is to say, we found a significant environmental justice benefit to these programs, even though there were few, if any, specific equity or environmental justice provisions in the programs as they were modeled. This equity-enhancing benefit arises because fossil fuel combustion has long been a primary driver in air pollution exposure disparities. Disadvantaged or low-income communities are more likely to be located next to highways, ports, and rail yards than average, and so are more exposed to pollution from these vehicles. Displacing fossil fuels with cleaner alternatives gets at the root cause of this particular driver of environmental injustice. While we would have to repeat the study for New Mexico to definitively say that the same result would apply here, a similar study by some of my co-authors found similar impacts in California. This suggests this outcome would be likely in New Mexico as well. Next, I want to highlight a common characteristic of all clean fuel standards that have been adopted to date, and that is that they will inevitably need amendments to adapt to changes in technology, markets, and policy. Designing an effective clean fuel standard requires modeling the anticipated supply of conventional and alternative fuels. This is a complex challenge and requires making a number of assumptions because alternative fuel technology is rapidly evolving and there are many novel technologies seeking to enter this market. Setting targets also requires projecting future fuel demand, which means making assumptions about population growth, economic trends, urban planning, etc. It is unrealistic to assume any analyst or modeler, no matter how well-skilled or well-resourced, can accurately predict the future many years out. And yes, I am including myself in that statement. Projecting the future is especially challenging given that we're talking about a program explicitly intended to support profound changes to our transportation and energy systems. This has two important implications for how programs like CTFP should be managed. First, it is very important to build robust modeling tools and resources. Investing in modeling and analytical capacity not only means there is a more robust toolkit when it's time to make changes to the program, but the process of creating, updating, and improving models serves as a form of program review and helps staff identify areas for improvement over time. Second, because models are imperfect, periodic program adjustments are going to be required. Every similar program in other states that has been in operation for more than 5 years has gone through at least one and typically multiple major amendment processes. California completed a major LCFS amendment process in 2018 and 2024, in addition to a couple of minor ones across the same time period. Oregon finished a significant rulemaking to update program targets in 2022 and is already beginning preparatory work for another, which is likely to conclude in 2027. This is not a policy that you can set up and leave to its own devices in perpetuity. The world changes and the policy must change with it. In most jurisdictions, these changes will require a public process with opportunities for community engagement and input from elected or appointed officials. While I'm not an expert on the details of New Mexico administrative procedure, it appears the same applies here. The final area of particular interest I want to mention is indirect land use change, or ILUC. In a field littered with complex topics, ILUC is quite possibly the most complex of them all, and I will do my best to simplify it for you here. Growing feedstock for biofuels requires agricultural land, and the rapid expansion of biofuel production around the world over the last 20 years means that a significant fraction of global agricultural land is now used for growing feedstock for fuel production. This occurs during a period where growing populations and rising incomes are also increasing the demand for food, which obviously also needs to be grown in agricultural land. This pressure to increase production can create an incentive to convert more natural land into farms. This conversion has consequences, however, one of which is the emission of greenhouse gases, as the carbon embodied in plants which were on the land is released back into the atmosphere by burning or decomposition. Conversion to agricultural land also releases carbon stored in the soil. Conversion to agricultural land also releases carbon stored in the soil. When tillage disturbs the plant matter that had fallen over decades or centuries and been incorporated into the soil. In many cases, the amount of carbon loss from converting natural land into agricultural land is so great that it would take many decades of constant production before the greenhouse gas benefits of the biofuel counteracted the emissions from land conversion. Though to be clear, the greenhouse gas impacts will vary from case to case because the amount of carbon held in plants and soil varies by location. These significant greenhouse gas impacts are why most biofuel programs, like the CTFP, as well as the Federal Renewable Fuel Standard, include sustainability provisions to prevent their incentives from supporting this kind of land conversion. Provisions banning the use of feedstock from recently converted land are a good step. Sure, banning from recently converted land are a good step, but the global agricultural commodity markets are big and complex, and market-mediated pressures to convert land can work in more roundabout ways. Programs can ban land that was recently converted from receiving incentives, but when a producer uses crops grown on existing farmland, they redirect those crops away from whoever consumed those products from that land in the pre-biofuel past. Whoever used to consume those products must now find an alternative source somewhere in the global marketplace. Somewhere in the world, someone will seek to increase production in order to satisfy this newly unsatisfied demand, and if their increased production comes by expanding their cultivated area into natural land, the GHG ecosystem and other impacts can still happen, even though they are not directly part of the supply chain for biofuel production. Another way of putting it is that the rapid growth of biofuels has expanded global demand for agricultural products. Even when a biofuel feedstock comes from long-established farmland, directing that production away from food markets and into fuel markets leaves a void in the food markets that someone will fill. The emissions from filling that void are ILUC emissions, and at least some part of them should be accounted for in the carbon intensity scores used by regulatory programs. If you don't accurately account for these ILUC effects, the fuels will be assigned lower CI scores than their actual impact, and therefore receive amounts of incentive in excess of what their actual greenhouse gas benefits would dictate. Inaccurate assessment of greenhouse gas impacts could even mean that fuels could receive credit under a program like CTFP, even if their real-world emissions are greater than those of petroleum. This has in fact happened in the 2000s and 2010s, when poorly designed European alternative fuel subsidies contributed to deforestation in tropical rainforests in Southeast Asia. Clearly, an alternative fuel policy meant to reduce greenhouse gas emissions must take steps to account for the ILUC emissions and avoid subsidizing highly destructive fuels. Quantifying ILUC impacts, however, is extremely difficult and complex. We can measure the total acreage of forest or other natural land types through aerial or satellite imagery, but not all deforestation is the result of biofuel policy. So it is not enough to simply know how much natural land has been lost. We need to assess why it was lost. This dependence on understanding the causality in a complex global economic system means that it is impossible to build a sensor that can directly measure ILUC. You could give me all the technology they have on Star Trek and an unlimited budget, and it still could not be done, because sensors cannot directly sense economic causality. Modeling and inference is required to do that. We start by building a model of the global agricultural commodity system, and then compare land use patterns and scenarios with specified amounts of biofuel production to scenarios without that production. If all else is held equal, we conclude that the changes in land use are due to biofuel production. The problem, apart from the profound complexity of modeling the international agricultural commodity system, is that this approach requires some assumptions about how the world would look in the future with and without biofuels. For many of these assumptions, there is no single objectively correct value to use, which further increases the complexity of these exercises and means they cannot completely escape subjective influence. While there are a handful of models that can nominally produce an estimate of ILUC impacts, the complexity and assumption dependence leads to a very wide range of answers coming from different models. In 2023, the US EPA compared ILUC estimates for soybean biodiesel, a comparatively well-known fuel available on the market for many years, from 5 models most commonly used for the purpose. They found the largest answer was about 30 times greater than the smallest, a massive range indicating the uncertainty and limitations of existing modeling tools. This is in part because there had been relatively little research support into the kinds of models needed to support regulation for most of the 2010s. Luckily, we are starting to see attention return to this space and hope to see improved tools become available in coming years, but at the moment, our analytical capacity in this space is limited. Given these limitations, NMED made the very defensible choice to use the ILUC adjustment factors developed by CARB for the California LCFS in 2016, at least until a better option emerges. While these ILUC factors are clearly in need of an update, they represent a good faith effort by experts in the space to address the question with tools that were widely accepted at the time. No conclusively superior set of ILUC adjustment factors has yet been developed to date, and the research community is, at a minimum, a couple years away from developing, testing, and validating a superior alternative. The CARB ILUC factors are used by Oregon and Washington, with the exception of Oregon's use of a different factor for corn ethanol. And so aligning with other existing programs in the US will minimize administrative complexity and compliance costs for regulated parties. New Mexico should adopt these with a clear and transparent understanding that they are a placeholder for an updated version to come in the future. But given the updated need to begin the multi-decade process of decarbonizing the transportation sector, this program allows programs like the CTFP to continue incentivizing gradual reductions in the carbon intensity of biofuels, as well as the displacement of petroleum in the meantime. With that, I will conclude my opening remarks, and I look forward to the discussion that will follow. Thank you for your attention.
Thank you, Dr. Murphy.
Thank you, Dr. Murphy. Madam Hearing Officer, if I may now seek to admit Dr. Murphy's exhibits. Thank you. NMED Exhibit 12 is Dr. Murphy's narrative testimony. NMED Exhibit 13 is his resume. And Exhibits 14 to 33 are those that are referenced in his testimony. I'd like to move for admission of those exhibits into the record.
Thank you. I'll pause for objections to the admission of NMED exhibits 12, 13, or 14 through 33. Okay, I don't hear any. They're admitted. Thank you.
Thank you. I will now hand my witnesses over for questions.
All righty. Thank you very much. I believe Namoga goes first. Mr. Mullenberg.
Thank you, Madam Hearing Officer. Good morning, Madam Chair, members of the board, and good morning to the panel. Thank you all for your testimony. So at the outset here, I think I have the pleasure of being the first to question a panel. So there are four of you, and just to clarify, not that I intend at all to use up all of this time, but I believe we would have, each questioner would have 2 hours total for the panel.
That's correct. It's as someone noted, we would be here for 48 days if we took that time. But Ms. Zona, did you have some response?
Yes, Madam Hearing Officer. I do want to seek clarification because your pre-hearing order specifically states that questioning of witnesses on a panel is questioning by witness. And so there's a 30-minute limit per witness, meaning that if a counsel asks questions for only 15 minutes, it does not mean 15 minutes is then later bled over into the others. So I wouldn't say it's 2 hours for this panel.
Right. No, I think I understood Mr. Molenberg. He said if he were to take 30 minutes with each witness, it would be 2 hours. And we talked about this in the pre-hearing conference. I think we're all on the same page.
Yes, and understood. I just want to avoid time with objections. And obviously, frankly, it's hard for any of us to keep track of time per witness. And just to clarify, at least from my standpoint in questioning a panel and for all of you, I may direct a question primarily to a particular witness, but it's my understanding that the members of the panel have some ability to say someone else might be the best person to answer that. So just for tracking purposes, it's kind of
Yeah. So long as you are not kind of clearly devoting, for example, 2 hours toward one person, I'll do my best. But I think we can trust each other to do this. And of course, the fact that another witness may have something to add is my favorite, one of the charms of a panel. So
agreed, and I approach it the same way. So I think we have a common understanding, and I can proceed from there. And it's certainly not my intention to focus all of the time on one witness.
Thank you.
So let me start with a couple of questions relating to qualifications and experience. And I would ask this question of actually the whole panel, if you could answer individually. I've taken a look at the information on your qualifications and experience, and my understanding is that none of the four of you has experience as a regulator outside of the New Mexico CTF program with with an agency who is implementing a similar low carbon fuel standard program. Is that correct?
It is correct that I have not worked for the state of California, the state of Washington, the state of Oregon on their clean fuel programs.
I haven't worked for a regulator. I was very deeply involved in the last two major rulemakings in California, submitted 150 pages or more of technical comment to the most recent one. But it was as an outside technical expert most recently, and then when I was with the environmental nonprofit on the 2018.
I too affirm that I have not worked for any other jurisdiction as a regulator of their clean or low carbon fuel program.
I have also not worked for the state of California, the state of Oregon, the state of Washington. I'll add Canada and British Columbia onto the list too of places I haven't worked.
Thank you very much. Appreciate those answers.
Madam Hearing Officer.
Ms. Sona.
So this manner of questioning is the exact issue that I was trying to raise in presenting my concern just a moment ago, that the pre-hearing order uses the term individual witnesses. I understand Mr. Mullenberg might be seeking to have some sort of efficiency in his cross, but the witnesses are to be examined individually. This is not a panel examination. And so in terms of the manner questions are presented and fairness, I do believe that the expectation is he needs to move from witness to witness and cannot just broadly ask questions of an entire panel.
So is not how I remember, and I may have misunderstood you when we were in that pre-hearing conference. Quest, is this happening? Again, there are various reasons I favor panels, and I think the efficiency, when that was a straightforward question, easily answered, that the efficiency introduced in that is preferable to a more extended cross-examination by person without being able to engage them as a panel. Again, if I detect Mr. Mullenberg abusing the that the cross-examination 2 hours should be focused on one person, for example, I would stop that. But right now, I think he's engaging in the kind of cross-examination of a panel that we ordinarily have in rulemaking. But thank you. Go ahead, Mr. Mullenberg.
Thank you, Madam Hearing Officer. Dr. Murphy, your resume indicates that you have worked on California legislation relating to its low carbon fuel standard, and I think you've talked about that a little bit. It also indicates that you, for a period of time, engaged in advocacy for a organization known as NextGen. Could you please just tell us a little bit about NextGen and particular points of your advocacy?
Yes, NextGen was a nonprofit environmental organization focused on advocacy primarily around climate issues, though over time they came to realize that single issue advocacy is challenging and took on a much broader portfolio. I started out in a position called a climate policy advocate, working primarily on legislation related to California's climate policy portfolio. We were engaged on getting SB 32 passed, which was the bill that extended California's broad climate authority past 2020, as well as AB 398, which extended the California, then called cap and trade, now called cap and invest market. We engaged in a number of other legislative topics as well as regulatory topics. During the 2018 rulemaking for the LCFS, we sponsored a research report from an outside consultant. I managed that project and then led a lot of organization around advocacy to CARB on sort of program design issues, target setting, provisions related to different quantification pathways.
Thank you, Dr. Murphy. You mentioned at the beginning this morning that specific questions regarding the New Mexico rules you'd prefer be deferred to staff, and I understand that, and certainly we'll try to honor that. But as in that regard, did you advise the department with regard to specific rule language that was incorporated into the proposed rule?
No.
And have you reviewed the proposed rule that's before the board today, or particular parts of it?
Yes. I've reviewed all of it sort of at a high level. There are a few issues where there have been discussions, but all of those occurred after the proposed language was published.
Thank you for clarifying that. And as it relates to your testimony, and I think you described this, but just to be clear, your testimony really focuses on general aspects common to low carbon fuel standard programs.
Yes, that's correct.
And some of those may apply to the New Mexico proposed rules. Some of them may not. Is that fair?
Yes, we have. In the research that we've done on related programs, we've noticed a number of common occurrences, sort of common behaviors and reactions from within the market. So I think that provides a strong basis on which we can infer likely outcomes in New Mexico. But I have not had the opportunity to create a model of the likely New Mexico market from which to base quantitative predictions with a real level of specificity. And so, yeah, that's why most of those questions at that level of detail I'll defer to the New Mexico staff and their contractors who have.
And thank you for that. And on the topic of modeling, my understanding of modeling is it can be multidisciplinary, but you do not hold a degree in economics, correct?
My degree is in transportation technology and policy. It is by nature an interdisciplinary degree. There is quite a bit of economics content in there. I have published papers in journals that look at the policy and economics of transportation. My degree is an interdisciplinary degree, not specifically an economics degree.
Thank you. So this morning, you've obviously covered a number of different aspects of LCFS programs in general, but one of the things that you covered this morning and in your direct written testimony is life cycle assessment. And you describe a life cycle assessment as looking at all activities needed to bring a product to market, including producing feedstock, refining it into fuel, and delivering it into the market.
That's correct.
And by a product, you're really focusing specifically on fuel products?
For a fuel program, yes.
Okay. And in this regard of life cycle assessment, in your view, is it appropriate to treat all fuels equally in the sense that they're evaluated in a life cycle assessment as you've described it?
Yes. I guess I'm not. There's a lot of detail and complexity embedded in that question, so I'm not exactly sure what you're getting at.
Fair enough. I understand too. There's a lot of complexity in this area, so I'm happy to hear you qualify your answer that way. But generally speaking, fuel should be evaluated on, let's say, an equal footing with regard to life cycle assessment.
Yes.
Yes. Thank you. You've spoken a little bit about kind of an overview of clean transportation fuel programs. And one of the topics that you started with is how the compliance aspect of a program works. And I think this is on page 4 of your testimony. You indicate that there are certain parties who have fuels with a carbon intensity higher than whatever is the current target. And is it fair to say that's pretty much gasoline and diesel within the transportation fuels arena?
If the baseline from which the target is assessed is set based on traditional transportation fuels, and those are gasoline and diesel, then yes. In early years of the program, it's usually just petroleum-based fuels that have a carbon intensity higher than the program's target. As the target becomes more stronger over time, we anticipate seeing fuels that maybe have started out with a lower carbon intensity gaining a higher carbon intensity. For example, in California, fossil natural gas, if it hasn't crossed that threshold now, it will in the next year or two. There's exceptionally little fossil natural gas in the California market, so it's sort of at this point a bit of an academic point. But we do anticipate that in the 2030s, some current crop-based biofuels might eventually flip and go from being a credit generator to a deficit generator.
Thank you. So just in terms of the mechanics of the program, you say at the end of each compliance period, which you describe as typically a calendar year, an entity that generates deficits must retire an equivalent number of credits to the regulator.
Mm-hmm.
That's kind of the mechanics of how the compliance piece works.
Yes.
And those who are supplying gasoline, diesel, and other transportation fuels to a particular market, those are the entities that are mandated to come into the program and comply, correct? So I think you say that the predominant way that these regulated entities achieve that compliance requirement is to acquire credits to offset their emissions. In that regard, are you thinking of purchases of credits or other means of acquiring credits?
It's been a wide variety in the jurisdictions that have adopted these programs so far. You see some activities to blend in lower carbon elements. You see some situations where conventional petroleum companies have entered into joint agreements to produce biofuels, or in some cases just bought biofuel producers or electric vehicle charging operators in order to generate credits internally, so within their own corporate structure. And in some cases, they will buy credits on the market. The program is explicitly designed to give a lot of opportunities for different commercial and contractual arrangements to allow the producers to find the lowest cost compliance option.
Thank you. You also mentioned another way is reducing the carbon intensity of their fuels. Is that done by various means, including blending lower carbon intensity feedstocks into a fuel blend?
Yes.
Okay. So, in your experience with these programs, if there are not, well, let me back up one moment. From your understanding of these programs, are credits fungible or transferable from state to state, or are they unique to a particular state's program?
They're unique to a particular state's program because the credit represents emissions relative to the target in the year that they were generated. So they're slightly different than, you know, an allowance under a thing like a cap and trade or a cap and invest program, which is sort of an absolute ton. You can almost think of credits in a clean fuel standard as a relative ton. So that means that, you know, in a situation like today where California's program has a roughly 22% carbon intensity target, but Oregon and Washington are somewhat below that, a gallon of fuel, of an alternative fuel delivered to California would generate a different number of credits there than it would in Oregon or Washington or elsewhere. So that means the credits are not perfectly fungible across boundaries. There are some sort of interesting academic discussions on how you might make them fungible. There has not been, you know, a lot of appetite to try that. They're relatively complex, and the feeling is, generally speaking, that states should have the ability to set their own targets in order to match the ambition of their program with the capacity of their state to decarbonize.
Thank you for that. And just from a mechanical standpoint, I think the implication of what you're saying, if you agree with me, is that if a fuel provider who is generating deficits within the New Mexico program needs to purchase credits, that can only be done with regard to credits that are generated or document within the New Mexico program.
Yes, that's correct.
Thank you. You mentioned on page 5 of your testimony that revenue from the sale of credits is transferred via private party contractors. And I think you touch on this somewhere else in your testimony as well. But in your experience, is data regarding the price of credits in these private sales reported to the state?
Yes.
And how is that accomplished?
Because the regulatory agency tracks basically where all the credits are, who's holding account they're in. Whenever a sale or exchange is made, it has to be reported to the regulatory entity, so the kind of database of where all the credits are currently sitting can be updated. And as part of that process, they're also expected to report the price. I believe there are maybe some small subtle distinctions in exactly how that's done in states, but the basic concept is you file a report regular saying, company A purchased this many credits from company B at this price. And that is documented, and then the agencies will usually publish aggregate averages on on whatever time basis they find most appropriate. I think California does weekly, monthly, and quarterly reports. I believe the other jurisdictions do monthly or quarterly.
Yeah. And are you familiar with the specifics of how that would be done under the New Mexico proposed rule?
Not deeply familiar, no, but my recollection when I read that part of the thing, it didn't jump out to me as being unusual, unless I missed something.
Thanks.
Unusual unless I missed something.
Thank you. On page 6 of your written testimony, there's a statement that a clean fuel standard will apply a persistent and gradually increasing amount of pressure on the market to reduce the carbon intensity of existing fuels. Are you familiar with the New Mexico carbon intensity reduction goals in the governing statute?
Yes.
Compared to your statement, is that a little bit different? Are those goals a little bit different than a persistent and gradually increasing amount of pressure?
Like I said a moment ago, the important thing is that the ambition of the targets is matched to the capacity of the jurisdiction's transportation and fuel sector to change. You want to sort of be pushing it to find ways to decarbonize and to find additional reduction opportunities, but not pushing so hard that you exceed that. Without having done quantitative modeling or sort of reviewed the existing modeling at a much deeper level of depth than I've had the opportunity to, I can't really say whether they're appropriate. They seem ballpark right at first glance, but also, as I said, these programs are always going to need updates. All the programs that certainly California, Oregon, and British Columbia have modified their target trajectories over time, and I would expect the same is likely to apply in New Mexico.
But at least from the outset, would you agree with me that the New Mexico carbon intensity reduction goals are more aggressive than at the beginning part of the program than perhaps have experienced in other states?
Yes, but in a lot of cases, other states were adopting these programs when there had been very little progress towards deploying alternative fuels or electric vehicles. And so some of that progress, through national programs or New Mexico's adoption of California policies under Section 177 before that authority was attacked. New Mexico is starting from a place further along than a lot of other jurisdictions that adopted these things 10, 15 years ago are.
Thank you. One aspect of the New Mexico governing statute is the concept or requirement of being technology neutral. When you were preparing your direct testimony, did you consider that specific aspect of New Mexico in terms of your general comments on how programs are developed?
Objection, Madam Hearing Officer. The witnesses clarified that his testimony is broad academic, not specific to New Mexico.
Mr. Mullenberg.
Thank you, Madam Hearing Officer. Frankly, that's exactly the point I'm trying to clarify is whether the direct testimony as presented here to the board is that general testimony or whether it considers this unique aspect of the New Mexico governing statute.
All right. And you don't think he's already said that, or?
No, I don't believe he has.
If you would, Dr. Murphy.
So I would say that technological neutrality, whether or not it's in the governing statute, has been identified by all the programs that have been adopted to date as an important characteristic of the programs. But I would also say that technology neutrality is not a term that has one and only one definition. There are enough assumptions that go into life cycle analysis modeling that there is sort of a set of definitions that you can make a very reasonable and substantiated argument that multiple definitions encompass the idea of technological neutrality. So the existing programs out there all, I think, take subtly different approaches at that, but all of them would likely claim that they are technology neutral.
I've got a lot of detail here. I'm trying to sift through it because I know I've been on this witness for a while.
In my device, you have about 14 more minutes with Dr. Murphy.
Thank you. More than I thought, perhaps. Dr. Murphy, I think in your direct testimony, you talk a little bit about how a low carbon fuel standard may be designed to provide signals for investment in various technologies and such. With regard to liquid fuel capacity, and I'm thinking of gasoline and diesel as well as renewable fuels. Is it important for a program to be fairly stable in terms of sending those investment signals?
Yes, if virtually any alternative fuel production capacity at commercial scale involves hundreds of millions of dollars of capital investment. So if a company is not confident that they're going to get that repaid, they're not going to make that investment, and supply is not going to be there. So understanding and having a predictable level of incentive is important to support those investments.
So is it fair to say that if a program signals, or within the program, there's a signal that certain types of fuels may have, or may at least be projected to have, a limited life, is that an influence on capital investments?
It might be. It is also important to recognize that no fuel producer builds, or certainly no liquid fuel producer limits themselves to one market. I think there's an expectation among fuel producers, at least the ones that I've talked to over the years, that they may switch markets over time. That as you have this dynamic of increasing targets, reducing the incentive available to certain fuels, they might choose to move to jurisdictions that are newer and sort of earlier in the process. So yes, they certainly would consider the fact that there is a declining incentive within any given jurisdiction. That is the case for all the existing states that have low carbon fuel standards, and has not prevented the deployment of fuels that will likely have sort of a limited duration of credit generation.
On page 11 of your testimony, you talk about the time frame that it takes to develop production capacity, and I think you talk about that for biofuels as a 3 to 5 year timeline.
Yes, there are obviously going to be some counterexamples, but yes.
Yeah. So these types of things take a long time. As investor signals go back and forth, perhaps one way or the other, that certainly has an influence on capital development. Would you agree with that?
Yes.
So on page 13 of your testimony, you talk about quantifying cost impacts from policies like the Clean Transportation Fuel Program. Do you recall that in your direct testimony?
Yes.
And within that, you discuss what's essentially a mathematical formula for doing so.
Yes.
Yeah, thank you. There's obviously other ways of doing that, but like most types of projections, whether they're based on a mathematical formula or they're modeled, there's quite a bit of uncertainty in terms of calculations or projections of consumer price impacts of fuels?
There is. With programs, like the LCFS in California and Oregon, we have definitely found some evidence so far that the pass-throughs tend to align with the theoretical cost impacts that I describe in my testimony.
Thank you. One of the ways that fuel suppliers can generate credits, and again, you talk about this on page 14, is through project-based pathways at refineries, correct?
Yes.
And your testimony indicates that that type of approach has generated a considerable amount of credits in California, right?
Yes.
So your testimony indicates that as a CTFP program implementation proceeds, that it's will tend to lead to gradually increasing gasoline impacts, price impacts over time. Can you comment on how the federal and California policies like 45Z restriction to import lower carbon intensity feedstocks impact the rate of which gasoline or diesel prices may increase over time?
That is going to be a complex question that, to be honest, I'd probably need a spreadsheet and some time to crunch numbers to speak about in a really informed way. There are definitely interactions between federal and state policies. Generally speaking, if there is more support provided at the federal level, less is needed at the state level, but that is not a perfect sort of one-to-one relationship. And I don't know what else to say without getting into pure speculation.
Fair enough. It's hard to do in a general sense as opposed to a quantitative sense. On page 26 of your testimony, you discuss estimates of retail gasoline price impacts estimated for Oregon. As we talked about a little bit earlier, New Mexico's statutory goals require a much steeper initial curve for carbon intensity reductions that has been required under other state programs, including Oregon. Do you have any opinion on how this difference in the New Mexico program compared with other states might affect retail price impacts on gasoline in New Mexico during the early years of the CTFP?
Objection, Madam Hearing Officer. Again, Dr. Murphy's explained that his opinions are not diving into how this program specifically works in New Mexico. And I believe a comparison question would be that type of speculation.
Mr. Molenberg, it does sound as though you're inviting something specific to the implementation here that Dr. Murphy wasn't present to discuss. Am I wrong about that, Dr. Murphy?
Generally speaking, yes. Specific numbers I would defer to NMED staff, particularly Michael Ford. The only thing I would say is, again, when you're thinking about early year ambition, the baseline you set matters a lot. And so, how much progress has been made prior to the formal initiation of the program matters as well.
Thank you. And again, my question was just whether he had an opinion. So I think we're good. So let me shift a little bit now. And the following questions are intended primarily for Mr. Vaughn. Mr. Vaughn, your direct testimony provides a lot of detailed information regarding the rule development process. Would you agree?
That's correct.
And by the rule development process, are we discussing, just so we're on even terms, the process leading up to the publication of the proposed rule for adoption by this board, or do you mean something different by that?
My testimony, the scope of it covers essentially from when we kicked off the rulemaking process in April of 2024 through September 2nd when we filed the petition proposed new rule.
Thank you. Just so it sounds like you're including rule development as a little more of an ongoing process that didn't really end with the publication of the proposed rule.
I'm not sure I understand the question. I think I just answered it by saying that I'm discussing it up until September 2nd.
Fair enough. And that's just what I was trying to clarify. So if I ask questions, we're kind of on even terms. I think
Sure.
I assumed that it would be up through the presentation of the proposed rule to the board. You've kind of extended that to at least September 2nd as part of the rule development process, right?
Sure.
Okay, thank you. And I'm focused in these questions really on the early parts of that process. So yesterday and in your direct testimony, there was some discussion of the formation and composition of the advisory committee. Do you recall that?
I do.
And I'd like to discuss with you some of the functions, particular functions of the advisory committee. First, I understand that there were 4 meetings of the advisory committee. Is that right?
That's correct.
Did any of those meetings last more than one day?
If my memory serves me correctly, I believe each of the meetings was approximately 3 hours in length, or a total of about 12 hours.
A total of 12 hours. Thank you. And was the purpose of the 4th and final meeting to review and discuss the draft report prepared by the department and to listen to public input?
Yes, the purpose was to finalize the technical report and also to take public input.
Thank you. And did the department itself make a number of presentations to the advisory committee?
The department presented 16 of the total 102 slides that were presented at the advisory committee. That were presented to the advisory committee.
Okay. Did any of the department presentations include any draft or suggested rule language?
I do not recall.
Okay.
The slides, though, are a part of the technical report that are included in my exhibits.
Thank you. So we could determine that by looking at the slides.
Yes.
Thanks. So you've mentioned that the meetings really were 12 hours total. So is it fair to say that the discussion by the committee members and among the committee members was time limited?
I don't think that would be fair to say because the department essentially created quote unquote homework for the advisory committee members. We offered prompts, essentially questions to the advisory committee members and asked them to consider those outside of the 12 hours that we actually met. That input was provided to us both orally and in writing. Orally, of course, was during those advisory committee meetings, and the written input mostly came outside of the 12 hours there.
Do you recall what was the total duration of the advisory committee process from the first meeting through, let's say, the publication of the final advisory committee report?
I don't know exactly off the top of my head, no.
Okay, but we could probably look at the specific documents and ascertain that.
That's right.
Okay. Do you recall how long committee members had? Well, let me back up just a moment. Did the department staff prepare a draft text of the advisory committee report?
Yes.
And was that then presented to the advisory committee's members for comment?
It was, and we received input from many members asking for minor tweaks to the language that each individual member was representing in that report, and those changes were updated and included in the final version of the technical report.
Thank you. And do you recall how long the advisory committee members had to provide those comments?
Again, I do not remember that duration.
That should be in the specifics of your exhibits.
It should be, yes.
Yeah. Okay. Fair enough. And then, if I recall correctly, the advisory committee report also includes an addendum of separate comments of the advisory committee members. Is that right?
Yes.
Okay. Do you recall whether the committee report included a text of any part of the draft rule?
I don't believe that it did.
Okay. But after the committee report was issued, and I want to say that was maybe September of 2024, does that sound about right?
Roughly, yes.
Okay. Did the department publish an initial draft rule for public comment around December 19th of 2024?
Yes, and as I testified in my summary yesterday, we took many of those recommendations from the individual members of the committee, and we, essentially tested some of those theories and recommendations with the other states to understand how the specific recommendation might affect their program, so that we could understand how it would affect ours as we were developing that. And yes, we did publish a discussion draft rule in December of 24.
And there were other recommendations from advisory committee members that you, or the department, I should say, did not accept, correct?
We accepted recommendations from advisory committee members as well as rejected recommendations from advisory committee members. However, I believe most of our effort was to balance the competing input that we received from the various committee members.
Thank you. And I think there's some discussion in your written testimony that talks about some of the recommendations that were not accepted and why. Do you recall that?
I do. You might have to refresh me on what page.
I'm not actually going to ask you questions about the specifics. My question is just, is there any other document or analysis from the department that's publicly available regarding the reasons why the department accepted or rejected advisory committee recommendations other than your own written testimony?
I don't believe so.
Okay. So I think there was some discussion yesterday that the department contemplates developing guidance regarding the CTFP rule after it's adopted.
Yes, just like every other state has done.
Do you know if the department intends to convene an advisory committee to review guidance, or whether there's any current plans on how to incorporate the advisory committee in the guidance development process.
Madam Hearing Officer, I'd just like to raise an objection that this is outside the scope of Mr. Vaughn's testimony, which discusses sort of the pre-rulemaking matters. This goes to implementation.
All right. Yeah, I do remember that testimony from someone else about reconvening an advisory committee in the future. That might have been Ms. Borchert, but I don't think it was Mr. Vaughn.
I guess in keeping with the panel, and so I don't have to start over, is that point addressed in your testimony, Ms. Borchert? And again, the point being the department's intentions regarding convening and potentially utilizing the advisory committee with regard to the development of guidance on the CTFP rule.
I'm happy to testify to what is in our rule regarding the convening of the advisory committee.
Does your rule contemplate utilizing the advisory committee in the guidance development process?
Let me turn to that part, which I believe is the 600s. Periodic Review, Section 603. It says, the advisory committee shall perform a periodic review of the CTFP performance and provide input to the department on whether adjustments are necessary.
So would you agree with me that language does not contemplate the advisory committee process being utilized for guidance development?
I would not agree with you.
Why would you not agree with me?
Because it doesn't specify whether the department would or would not use the advisory committee for that purpose.
Does the department have a plan with regard to the use of the advisory committee process during rule guidance development?
In general terms, I would say that we will be presenting the advisory committee with the documents that are required as part of our periodic review, right? And also part of our public disclosure. And looking at the various parts of the program, and really at the time when the advisory committee is convened, thinking about what the best use is of the experts that are convened in that process, and determining their use. Guidance documents are often kind of niggly details about how do you access the DMS? How do you get your invoice? How do you pay your invoice, right? And I think that the convening of experts, as we did in the advisory committee process, to review guidance documents about how to pay an invoice seems not worthy of their time.
Can guidance documents address a lot of other topics, though, like carbon intensity calculations and the like?
No, I don't see guidance documents addressing carbon intensity.
So when the department discusses or has discussed the development of guidance documents, would it be fair to say that you're contemplating guidance documents on more administrative details?
We have, I believe Washington has over 1,000 guidance documents. So I would recommend that you ask us what kinds of guidance documents in particular you feel like advisory committee input is worth on. I mean, my understanding is the majority of those are just to set up the program. And if there are items that seem like the advisory committee we could benefit by their input, then I think we would be open to that.
And fair enough. That's perhaps a good approach. But that begs the question of when the department might reconvene the advisory committee. So there are advisory committee members who could make those kinds of suggestions, right?
So was the right the question? The right question mark? Right, that would beg the question.
Madam Hearing Officer, it's about 10:30. Just wondering, I'm perhaps at a little bit of a stopping point here. If you want to take a break or if you'd like me to finish, I can go to the next witnesses.
All right. No, that would be good. Would you estimate the time of your questions? Just estimate.
I'm obviously, I don't have any more particular questions for Dr. Murphy. I'm about finished with Mr. Vaughn. And obviously, then I have a number of questions for Ms. Borchert. So I'll probably be getting pretty close to my 2 hours, frankly.
All right. Let's take a 15-minute break. I have kept track of the time. That puts us back at 10:48.
Thank you.
The clean line version is NMED Exhibit 1, and the red line version is NMED Exhibit 2.
Thank you. I appreciate your making the record clear on that point.
Well, hold on, Mr. Mullenberg. We may be having a technical difficulty.
Looks like I just got fixed.
Just one. Oh, we're good?
Can they hear someone?
Okay. Okay. Thank you very much. I'm sorry, Mr. Mullenberg.
No problem. Thank you. So I appreciate you including a summary of all of the changes, and it looks like this goes from page 25 of your testimony through looks like around the bottom of page 29. Is that correct?
Yes, that does look correct.
Right. And do you know if there's any other testimony by any other department witness on the summary and reasons for the changes as shown in the version of the proposed rule filed on September 2nd?
No, I don't believe any other NMED witness included this type of comparison between the petition and the revised rule.
Okay. So this is a pretty complete statement of both a summary of the changes and the department's reasons for making those changes. Is that fair?
This is a complete list of the changes that were made, and the department's reasoning is sometimes presented and sometimes not.
Fair enough. And just to clarify that, is what you're saying that the board might find reasons for changes in various parts of the testimonies of the department's witnesses?
I'm sorry, could you repeat that? I'm not sure I understood that.
Yeah, sorry for not making that clear. I was just trying to clarify your last answer that suggested that maybe some of the reasons for these changes are in these pages that I referenced in your testimony, and some of them may be elsewhere. Is that what you're saying?
No, I'm saying that sometimes these changes were they were made and there was not a lot of detail given as to their change. I also want to add that I did add for particular issues that I felt like were maybe more important to the board. I added more language in my oral summary about these changes.
Okay, so we can refer back to your oral summary as well as what you have in here.
Yes.
Okay, fair enough. So at the bottom of page 27, you discuss a change relating to the program credit clearance market and the triggering of that market. Could you explain a little bit further to the board what the credit clearance market is and how is that triggered?
Yes. I'm also going to go ahead and let the board know where that occurs in the rules in case they want to see the language in the rules. So the credit clearance market starts in section 507 under the demonstrating compliance section. And it starts on with subsection I. And I also think it's a good opportunity to really frame what the credit clearance market is. So, and it's considered a compliance mechanism. So, in this situation where a deficit generator has not been able to demonstrate compliance, as in purchased enough credits to offset their deficits, then there's various provisions for trying to bring that deficit generator into compliance. And one of the options is that the department begins the credit clearance market process. And so this is basically a series of steps. First is the decision that this is the right path to follow in order to, and what it essentially does is offer up credits for into the market that then any party or parties that have not purchased enough credits can buy credits. Now, I also want to say that, this is, as I mentioned before, multiple steps that could lead to this. And there's a couple other big ones that we haven't really touched on yet that I think are also important to note that are other opportunities for compliance. One is there's a in all the other programs, there are people who are aggregators, and their jobs are to, or their business model is to basically look where are credits not being generated by the party that is the first fuel reporting entity, the person who could produce those credits, and then they go and they enter into contracts with those entities to then create the credits on the behalf of the people who have the opportunity to generate the credits, and then enter those into the market, right? So there's always aggregators often have credits, and the other people who have credits are what we call the backstop aggregator. They are eligible to get credits that that haven't been generated by aggregators or first fuel reporting entities.
And Ms. Borchert, sorry to interrupt you. I apologize for that, but is there somewhere else in the testimony that the commission or the board members can look to kind of get a general explanation of this?
It's in the rules. No, I don't know that there's the summary. I think I do talk about, I talk about the third party aggregators, the aggregators a little bit. And I also, the backstop aggregator is mostly in the rules. The backstop aggregator is a pretty straightforward section of the rule.
So pretty much the board members would just need to read the rule language itself to advise themselves on what's going on here.
That's right.
Now, is the credit clearance market dependent on there having been credits determined by the department and documented or established, if there's a better word, let me know, within the CTFP DMS system?
Could you repeat that question? By the time you got to the DMS, I'd forgotten what the first part was.
I'm sorry, it was a long question. I'm just trying to get to that for the operation of the credit clearance market, you need credits to have been determined or awarded by the department, and those need to then show up in the department's system that manages credits, right?
That's right. The DMS is the system in which people report their fuel transaction. They then earn deficits and credits, and then they report transactions, as was mentioned earlier. So yes, it's all in the DMS and then they also demonstrate compliance. So, an example of the credit clearance market, the compliance period ends April 30th, and then it'll be obvious for all the registered parties who is in compliance and who is not.
Okay. Let me go through a series of questions that kind of get to, I'm really kind of getting to the mechanics of the program, particularly from a compliance perspective. And I think you're really the witness who addresses those issues in your testimony on the mechanics of the rule.
I would like to caution you that actually it's a combination, right? Because Dr. Rosso is also really astute on the implementation, which means, but we can be fluid around that, perhaps.
Fair enough. And if I ask a question that's better responded to by Dr. Rosso, obviously you can do that. So, first of all, is it true that only really the gasoline and diesel providers are the ones that have no choice but to be regulated under the CTFP?
No, that's not true. The list of regulated entities are on page 100, and they include also, for example, hydrogen, and let's see, fossil natural gas, ethanol, biodiesel, renewable diesel. The list includes 11 specified fuels, synthetic fuels, and then a general category of the blends of types of transportation. Yeah, anyway, so it's not just gasoline and diesel.
Thank you. And let me get back to a point I thought I heard yesterday, and correct me if I'm wrong, that I think you said that essentially all of the folks on the list that you mentioned really can opt in to the program. They're not mandated to come into the program, whereas those who supply gasoline and diesel and perhaps some other transportation fuels to New Mexico have no choice but to participate in the program.
Objection, Madam Hearing Officer. To avoid the risk that counsel is misstating Ms. Borchard's testimony from yesterday that was given orally, I'd ask this be framed in a specific question rather than to confirm prior testimony.
Oh, Mr. Molenberg?
Well, Madam Hearing Officer, that's precisely what I'm trying to do. I mean, I thought I understood the witness say yesterday that essentially the other participants have the ability to opt in. Perhaps the witness meant something a little bit different by that, but that's really what I'm trying to ask here is the point that Ms. Borchard's referred to a list of parties, and maybe I'll use the word compelled. Which ones are compelled to participate in the program
versus the ones
that are not, recognizing that certain of these parties certainly have to participate in the program if they want to generate and sell credits.
I do remember the opt-in testimony. If you would clarify that, Ms. Borchard.
Sure. The list I just read from 101B is the list of regulated transportation fuel. So if they import, produce, or dispense for use gasoline, diesel, fossil natural gas, fossil LPG, ethanol, hydrogen, biodiesel, renewable diesel, renewable naphtha, renewable gasoline, synthetic fuel, and blends of those, they're a regulated party. The opt-in list is in C: electricity, biomethane, renewable LPG, alternative jet fuel, and blends of any of those above.
Thank you. That's helpful. So what we're really saying, I'll use ethanol as an example. If someone is supplying ethanol to the New Mexico market, then they're required to register and do the reporting and other obligations under the rules.
Yes.
Thank you. So for all of these parties then that I think we talked a little bit about, the first step is they register in the CTFP DMS system, right?
Yes.
And then once the program is implemented, they have to start making their fuel reports quarterly, correct?
Correct.
And then once the quarterly reports come in, the department begins the process of calculating debits and credits, correct?
I think we're veering a little into implementation here, so I'll start
Fair enough.
answering.
Yeah.
Yes, the credits and deficits are calculated by the data management system and put automatically into the registered parties' accounts once the quarterly fuel reporting is complete.
Thank you. So that's really something that's automatic within the system.
Yes.
Does it require manual? Is there a review or reconciliation process done, or?
The way this typically works is during that quarter of reporting. So, for example, for reporting fuels that were delivered or produced in the first quarter, the reporting period is the second quarter of the year. And the first 45 days of that quarter are typically straight reporting, and the second 45 days are reconciliations.
Okay. And reconciliation, is that a manual process or a computer systems process?
It's both. It's a mixture. Typically, it's because specifically in liquid fuels, there are several fuel reporting entities, and all of those transactions have to match up. So it's typically reconciliation between business partners, not with the department.
Okay, fair enough. I think I see what you mean there. So going back to gasoline and diesel, I'll say regulated parties. Tell me if I'm using the wrong terminology. Those are the parties that are going to generate most, and I would say the vast majority of deficits. Is that fair?
I think the exception there is ethanol, right? Ethanol has a CI that is lower than the standard, and ethanol producers are always trying to find more ways to reduce their CI. Hydrogen really depends on how it's produced. It's listed here because, there's a range of ways you can make hydrogen. It all depends on the process used. Same with biodiesel. So I can't really say that this list of regulated parties are going to be generating most of the deficits.
Well, and Ms. Borchert, I think that's a little bit on a different point. Let's say at the beginning of the program, it's going to be those regulated parties who provide gasoline and diesel that are going to account for the vast majority of deficits at the beginning of the program, correct?
Yes.
Okay. And as I think we heard from Dr. Murphy, those parties, in order to balance out their deficits, have to acquire sufficient credits through the New Mexico CTFP program, correct?
Correct.
And in order for them to do that, those credits have to be, I'll say, shown within the CTFP system, right? In other words, they can't acquire credits from outside that system, right?
Yes.
Okay. So I think we've distinguished between the parties specifically listed as opt-in parties, such as those involved in the electricity part of the equation, right?
Yes, electricity is an opt-in party.
Yeah, and I think you've said that, say, an ethanol producer who delivers ethanol in New Mexico, they have to come into the system, and to the extent that they generate credits through their deliveries of ethanol in New Mexico, those would be reflected in the CTFP system.
That's right. Yes, and they would show up as credits until they cross over the standard, as Colin explained, can happen in later years of the program.
Thank you. And I think this specifically goes to the opt-in piece here, but has the department done any surveys or collected information to assess when the credit generators might come on board into the CTFP system?
I am going to pass it over for Dr. Rosser to talk about electricity specifically.
Thank you.
So speaking specifically of electricity, the largest portion of credits will likely come from residential charging of electric vehicles. And those credits are generated by the department and deposited into an account. And they're generated and deposited into an account whether or not the electric utilities have opted into the program. So in the event that the EDUs, the electric distribution utility, that would normally receive the credits hasn't opted in, those credits go to the backstop aggregator.
So what you're distinguishing between is an electric utility provider opting in versus someone who, I guess you're addressing the mechanics of how the charging folks come into the system, right?
I'm addressing specifically how the credits for electric vehicle charging come into the system, regardless of if the utilities have opted in or not.
Okay. Has the department made any projections of the amount of credits that would be available, say, in the first quarter of the CTFP program after it's implemented?
I think I would have to refer that to other witnesses.
Okay. None of this panel would
Not this panel.
have that information. Thank you. So let's say that the CTFP program is fully implemented in the middle of 2026. Would 2026 then be the first compliance year?
Well, I'd like to just highlight that we don't think that this should start with implementation July 1. We think April 1 is a reasonable implementation date, but yes, as soon as the implementation date begins, or the effective date, then in the quarter, partial quarter, full quarter that follows that effective date, parties would both be generating credits and deficits.
And in any event, regardless of when or whether the program is implemented in 2026, or I should say that differently, assuming the program begins full implementation sometime in 2026, the end of the 2026 compliance year would be the end of the calendar year, and all of the parties who, particularly those are generating deficits, would have to balance out their books, so to speak, by the end of 2026?
There's always a lag period, right? So the fuel deliveries occur in, let's say, the last quarter of 2026. The reporting happens in the quarter after that. The credits and deficits get generated into people's accounts the quarter after that. And then for the 2026 year, let's say, or whatever period in 2026 the program begins and is effective, the compliance date is April 30th of 2027.
So just to clarify that, the balancing of the books, so to speak, is done on the basis of the end of the calendar year, but the all of the reporting and completion of the process lasts through the following April. Is that fair?
Correct, April 30th. I don't know if I said April 1st,
Okay.
but it's April 30th. Yes.
Okay, fair enough.
I'd like to also add that the compliance period reports are due April 30th, and there is a mechanism in the rule called carryback credits that can be purchased for compliance in the previous calendar year.
So for a carryback credit, those would be, let's say, credits generated in maybe the first quarter of the following year that can be used to offset deficits occurring in the prior calendar year. Is that what you're saying?
If you give me 1 second, we're going to find it in the rule.
Okay, good. Thanks.
My apologies. This is taking us a minute. So we're speaking about section 507F, extended credit acquisition period, which says a regulated party may acquire carryback credits between January 1 and April 30th each year that the regulated party may use to meet a compliance obligation for the previous compliance period. A regulated party shall complete all carryback credit transactions in the CTFP DMS before compliance obligation for that compliance period.
Thank you. So the carryback provision you've mentioned, that's helpful. But and again, I'm interested in really the issue of what happens if, particularly in the first year of implementation, there's a shortage of credits that can be used within the New Mexico CTFP system to satisfy each of the deficit generators' deficit obligations or obligations to offset deficits. And I think so. You've talked about this carryback provision that we just mentioned. One of the other potential provisions in the rules for relief for the deficit generators who want to and frankly are compelled to comply.
Madam Hearing Officer,
Miss Sona.
this is reaching council testifying. Can we get to a question, please?
It was going on. Mr. Mullenberg, I know you were framing it as you were going on.
I know, and obviously I'm trying to move this along. So
Yeah.
given the time limits, I'm trying to get to the deferral questions about the deferral mechanisms. And I'm not sure. I think that's probably Ms. Borchert, so I'll start there. But if somebody else needs to answer on the deferral provisions. So I think yesterday you mentioned that, as I understand it, there's two deferral provisions, one for emergencies and another for forecast deficiencies in credits and perhaps some other circumstances. Is that generally correct?
Yes, that generally is correct.
Thank you. And for the emergency deferral provision, I think you described that as being invoked for force majeure type circumstances. Is that right?
Yes, the language in the statute, or I'm sorry, in the rules actually says the existence of an extreme and unusual circumstance.
Would that include an imbalance between available credits and the amount of accrued deficits?
No, that's not an extreme and unusual circumstance in the way that it's considered here in the emergency deferral. This is more like things happening external to the program that influence the ability for somebody to either credit generation or deficit to be able to meet their obligations.
Is that deferral provision, and thank you, because what you just said is consistent with my understanding, is that deferral provision intended to be applied on a regulated party by regulated party basis or on a statewide basis?
It is not, it doesn't define what type of extreme and unusual circumstance is. It could be either of those situations that you just described, because these kinds of unusual circumstances are hard to predict, and the rule allows for flexibility depending on what it might look like. It could be that, one refineries, refinery catches fire and is not able to provide fuel, or it could be that we have another COVID-like situation that impacts everybody. It's hard to know because these things are indeed extreme and unusual.
Yeah, thank you. And that just tells me that may be an open question under the rule. The other deferral provision relates to forecasted circumstances, right?
Yep, and it's just so that any board member who wants to actually understand where this is in the rule, this is
that's okay. I don't want to take the time to, and I don't intend to go through the mechanics of that, but just one question on that. The forecasted provision is a forward-looking approach that requires the department to do some studies to make a forward-looking forecast, right?
Yes, indeed.
Thanks. And in order to make that kind of a forecast, you have to have a reasonable amount of data that allows you to do that, right?
Correct.
Has the department considered when might be the first opportunity for it to start the forecast deferral process?
Yes, the department would consider doing the forecast by the deadline in the rule of October 1, 2026.
But again, depending on when the program is implemented, the department would have a pretty limited amount of data to make a forecast at that point in time, right?
I guess you're presupposing we have a limited amount of time to do that. So let's see, October 1 would be, there could be 1 quarter's worth of data, but not really, because it would be reported the previous year, so previous quarter. So yeah, let's hope that this program is up and going by April 1, which means there's a quarter plus worth of data to work with.
So let me move to a different topic, which is
Mr. Mullenberg?
yes.
I'm sorry to interrupt. Your time with Ms. Borchert has come to an end, and you have about 20 minutes left with Dr. Rosso.
Okay, thank you. And I don't know if you've timed that separately between Ms. Borchert and...
I did.
Okay, fair enough. I was going to move on to fees. Is fees a topic that you're familiar with, Ms. Borchert, or is that really covered? Or I'm sorry, Dr. Rosso.
I'm not as familiar as Ms. Borchert, but I can answer in a limited capacity.
Fair enough. So again, to the extent you can't answer questions related to fees, I guess we'll figure out how to pick that up later. There was, do you know if the department has prepared any estimates or projections of the relative amounts of time that it anticipates spending on work for, let's say, associated primarily with regulated parties who generate deficits versus those who are more likely to be reporting credits?
I'm not aware of a formal analysis, but it is something we've discussed with other states.
Okay. Are any of those discussions represented in any of the department testimony or exhibits?
Objection, Madam Hearing Officer. Counsel is asking the witness to characterize the reference of the entire record of NMED. I don't think that's a fair question.
So if Dr. Rosso knows, she can say whether she knows or not.
I'm not sure.
Thank you. So, Dr. Rosso, I understand that you are involved in some of your direct testimony covers the development by the department of the CTFP DMS system. Is that right?
That's correct.
Okay. And do I understand correctly that as the starting point for that system development, you've acquired the code used by CARB in California?
That's correct.
And will the department need to make some adjustments to that code for the New Mexico program?
Yes, we began making those adjustments nearly 6 months ago.
Okay. And are you doing those adjustments in-house, or do you have a contractor working on that?
We have an IT contractor as well as NMED's Department of Information Technology.
Thank you. So it's a combination. Is it fair to say those kinds of adjustments might need to be continued up through and after the time that the board promulgates a final rule?
Yes, we have scoped out the development of our data management system to be concurrent with the deadlines that are in our proposed rule.
And I can't remember. I think you maybe have suggested different dates for that implementation, but let me ask, does your plan contemplate completing that work on the CTFP DMS code by February of 2026?
The elements of the code that need to be complete for the program to commence on February 1st will be complete by February 1st.
Right. And then if the rule is adopted later, those adjustments would have to come later, of course, right?
I don't know how the rule being adopted later would change the adjustments.
I guess I'm just contemplating that the provisions of the final rule might be different than what the department has proposed, possibly. And if that's the case, there would be some adjustments needed, right?
That would be correct.
Okay, thank you. Does the department have plans in place for testing and debugging that code once the work is, I'll say, ostensibly complete?
Yes.
Okay. Having a CTFP DMS system up, running, tested, debugged, and so forth really is essential for the program to begin, starting with registrations. Is that right?
That's correct. That's why we began development of this system so far in advance of even bringing the rules before the board.
Okay.
Of even bringing the rules before this board.
Um, so, is it fair to say, or is it your understanding that regulated parties also need access to the CTFP DMS functioning properly so they can develop their own systems for compliance and such?
I think that's fair. And I'll also add that we have endeavored to make our system as similar to other states as possible. We expect many of the regulated parties to be the same as other states, and I believe that will aid in their adoption of our system.
Does the department have any estimate of the number of regulated parties within different classes that are likely to participate?
Not that I'm aware of.
Okay. Dr. Rosso, are you familiar with the provision in the rule that deems the carbon intensity value for renewable electricity as 0?
I am.
Okay. Is that a statutory mandate in NMED's opinion?
Objection. I think this borders on asking for a legal conclusion, perhaps reframing the question.
Can you rephrase that then?
Can you describe why the department chose to propose in the rule to deem the carbon intensity value for renewable electricity as 0?
I don't recall our exact reasoning, but I will say I believe it is deemed as 0 in other states, and the life cycle analysis of renewable electricity as a transportation fuel also results in a carbon intensity of 0.
Okay. Can a carbon intensity value for a renewable electricity source be calculated using the R&D GREET model?
I believe so.
Okay. And in looking at that calculation on a life cycle basis, would a model or other source consider all of the various inputs as Dr. Murphy described to come up with a life cycle carbon intensity?
I'm sorry, could you repeat that question?
Yeah,
I got
that
a
was
little
long
lost.
question. I guess what I'm getting to is, if you look at renewable electricity from the standpoint of manufacturing the equipment, transporting equipment, constructing a site, and all of those things, all of that would be considered in a life cycle analysis, right?
That would depend on your system boundary selections for the life cycle analysis. Typically, construction of the facility to produce electricity is outside of the transportation fuel system boundaries, in the same way that construction of a refinery is outside of the system boundaries for a liquid fuel.
Okay. Yeah, I might want to explore that further with another witness, but I guess what you're saying is that within the calculation of life cycle carbon intensities, there are some boundaries drawn at some point between what you consider and what you don't consider?
Yes, if that was not the case, you would consider the whole world for every fuel.
Okay. Let me go a little bit to fuel supply equipment credits. Is that a topic that you've addressed in your direct testimony?
I believe so.
Okay. My understanding is that those credits are based upon the capacity of the equipment to dispense fuels rather than the actual amount of fuel dispensed. Is that right?
It is the actual number of credits awarded to an FSE pathway holder would be dependent on both of those things.
Are there provisions in the rule that address potential double counting of those aspects, both capacity and dispensation of fuel?
There are provisions in the rule that prevent double counting between the two.
Okay. But as to the capacity aspects, the holder of a fuel pathway for a fuel supply equipment credit would get credit for the capacity regardless of the fuel dispensed, correct?
They get credit for the unused capacity. In other words, the capacity, they get credits for the amount of time the fuel supply equipment was not utilized.
Okay.
Equipment.
So they get credit for the time that the capacity was available but was not used. Is that what you're saying?
Yes.
Okay, fair enough.
And I should add, they also do not get credit for the time that the equipment was unusable or unoperational.
Yeah, okay. Thank you for that. Let me move to a final topic, which is verifiers. I think you've addressed that in your direct testimony. Is that right?
I believe so.
Okay. So if the board cares to look, there's a pretty long section of the rules regarding verifiers. Is that right?
The section is lengthy.
Yeah.
Lengthy.
And remind me which section that is?
508.
508. So one of the provisions in there is the conflict of interest provisions, right?
That's correct.
Okay. And again, my recollection is those are fairly lengthy. In applying the proposed rule provisions regarding conflicts of interest, are conflicts of interest considered only as they arise within the New Mexico CTFP, or are out of New Mexico conflicts also considered?
If you give me 1 minute to find the conflicts of interest section.
Thank you.
And for the benefit of everyone following along, it's 508 T.
T as in Tom.
T as in Tom. I believe that the conflict of interest evaluation would include activities that occur outside of New Mexico.
Okay. Has the department conducted any surveys or gathered any other information on how many verifiers are likely to apply for work within the New Mexico program?
Not that I'm aware of.
Has the department developed any estimates or projections on how long it anticipates the verifier application and approval process to take?
We have simplified our verification, third-party verifier application process compared to other states. In essence, we've provided that companies and verifiers that are certified in other states, it's a very simple process for them to be re-verified or recertified in New Mexico.
Thank you. It's a simple process in some respects, but obviously they still have to go through and qualify under all of the conflict of interest provisions and analysis. Is that right?
The conflict of interest parameters apply regardless. I'm sorry, could you repeat the question? I lost track a little bit.
Yeah, thank you. It's getting long for me too. What I'm asking for is, I think you've testified that the verifier application and approval process has been simplified compared to other states due to the rules accepting verifiers from other states. But one aspect of that is that a verifier applying for work in the New Mexico program would still have to submit all of the information regarding conflict of interest, and the department would have to evaluate that and conclude that they qualify with respect to the conflict of interest provisions, right?
Yes, that's true. I'll also add that there is one caveat on this as it applies to alternative fuel pathway applications and requirements for third-party verification on those. Any parties that hold an alternative fuel pathway in another state are required to submit previous third-party verification reports relating to that pathway that they've conducted for other states. They are not required to undergo a new third-party verification before submitting the application to NMED.
Okay, fair enough. I'm just seeing if I have anything else that I might have time to cover with you. Dr. Rosso, I believe, yep, is it Rasso or Rosso? I'm sorry.
Rasso, like El
Rasso.
Paso.
Good. Got it. Got it. I apologize. I add the other kind of A too often. If I recall correctly, yesterday you made a comment with regard to the use of the R&D GREET model in the context of compliance. Does that sound familiar?
Vaguely familiar. I think I stated that it's not, the R&D GREET model is not intended for regulatory compliance.
Could you clarify your meaning of what you mean by compliance, and particularly in the context of the use of the R&D GREET model to calculate carbon intensity values?
Carbon intensities, particularly the carbon intensities of transportation fuels, are a integral part of how this type of program works. And small changes in the carbon intensities of fuels can make a big difference in the number of credits and deficits that are calculated. So I think it's very important that everyone who is applying for alternative fuel pathways and fuel pathways be on a level playing field and be compliant with the rules of the program.
Okay, fair enough. I mean, I think that answers part of the question. I guess in your statement regarding the use of the R&D GREET model for compliance, are you considering the calculation? Well, you're not saying, if I'm understanding you correctly, that the R&D GREET model is not appropriate to be used to calculate carbon intensities within the New Mexico CTFP?
I am saying that the straight R&D model, which is R and D, like research and development, for the benefit of the court reporter, is not appropriate to be taken off the shelf, so to speak, from Argonne National Laboratory and used directly in the program.
Okay. And by that, are you getting into the topic of making sure that the use of any model to calculate a CI value is appropriate for a particular fuel pathway?
I'm sorry, I don't understand the question.
I'm sorry, and I probably don't state it too artfully, but I'm gonna move on from that. One of the aspects of the department's development of its own model for carbon intensity calculations is the refinement of the input as it relates to crude oil. Does that make sense to you?
Yes.
Yes. Okay. Um, in looking at the mix of crude oil supplied to New Mexico, for purposes of that analysis, what sources of data did the department use on to determine or estimate the actual crude sources of crude oil used in New Mexico?
This work was done for the department by Eastern Research Group, and that would be detailed in their report.
Okay, so we would look to the ERG reports and such for
Yes.
that. And will that be covered by Mr. Kupal?
He is testifying to that report.
Okay, and I'm sorry, I don't recall if it's Mr. or Dr. Kupal at this report, but fair enough. Okay.
Mr. Mullenberg, you're coming to the end here.
And thank you. I think that I think I can wrap up there.
Great. Thank you so much.
Thank you, Madam Hearing Officer, and thank you to the panel.
Mr. Tucker, we are closing in on the noon hour. If you wanted to take your first 10 minutes, that's great. Thank you.
Madam Hearing Officer. While Mr. Tucker gets prepared, I just want to make a global objection, if you will. I did withhold numerous objections to counsel testifying after the witness had answered the question by clarifying his opinion of what the answer was. And I would just like to ask that counsel avoid that manner of cross-examination as it delves into testifying.
All right. Thank you, Ms. Donna. Mr. Tucker.
Good morning, Hearing Officer Orth, Chair, members of the board. My name is Aaron Tucker, representing Oxy USA. Good morning, panel. This morning, I'll start with the cross-examination of Dr. Murphy, and we'll see how far I get before the noon hour, and then we can just take it up after lunch. Sound good?
Thank you.
All right, great. Dr. Murphy, in your written testimony on page 11, you stress the need for long time horizons and policy certainty to unlock investments for clean transportation fuel projects, correct?
Yes.
Can you please explain what you mean by policy certainty?
So, as I mentioned in, I think, an answer to one of the questions earlier, alternative fuel production capacity is a very capital intensive process. So if a company is going to be investing several $100 million into a project and relying upon the incentives from a program like CTFP, they have to be relatively confident that the incentives will be sufficient in both kind of the amount and the duration of the amount to allow that investment to be paid back.
So the specific policies in a clean fuels rule can influence companies' investment decisions. Is that right?
Yes. No company is going to walk into this with the expectation that they're going to precisely understand what they get, 10 or 15 years out. But it is important that they know there will be a program, in more than 5 years or 10 years, and have at least a approximate idea of the level of incentive they're likely to receive from it.
Thank you. On page 11 to 12 of your written testimony, you state that a lack of policy certainty contributed to California LCFS credit price volatility in the late 2010s and early 2020s in California. What was the price volatility that California experienced?
So in the middle 2010s, the credit prices were, we call them on the low side, in part because there was uncertainty about the extension of broad climate authority under which the LCFS was allowed to operate. There was also a lawsuit over kind of procedural violations working through state court that had frozen the targets at a certain level, at a 1% level for a number of years. Once that so because there was between the legal uncertainty and the policy uncertainty due to lack of authority, there was not a lot of investment going into the market. Parties just weren't sure if the program was going to be there past 2020 or at what level of ambition or incentive they might be able to expect. Once SB 32 passed and the rulemaking to readopt the LCFS and extend it beyond 2020 occurred, and they had an idea of both that this program was going to go through 2030 and what the target level was going to be. There was very obvious understanding in the market that there was going to be a lot of credits needed to comply, and so the credit prices went up. They approached the $200 ceiling. Didn't hit it, but started getting at least into the neighborhood, because for so long they had been kind of forced to sit out and wait to see, is this program going to exist or not, and then everybody had to jump in and procure enough credits to have an adequate reserve. That sort of persisted for a while, and then because you had this sort of sudden everybody into the market and prices went up when COVID came along with some developments in the national biofuel supply system, that the oversupply that was predicted emerged sooner than we thought, and credit prices then went back down in California.
Thank you. So I heard you mention the legal uncertainties, and at the beginning you mentioned specific policies that were uncertain. Could you please clarify what that was? It was a little hard to hear.
So the legal uncertainty, there were lawsuits at both the federal and state level. The federal lawsuit was, and I'm not a lawyer, but my understanding was that it was around the Commerce Clause. That was ultimately not successful. The program was not violating the Commerce Clause. The state lawsuit was on how CARB considered increased NOx emissions from certain types of biodiesel, as well as some procedural issues, and that made it to the state Supreme Court, and the remedy was sort of redo the rulemaking to fix those issues, and the program eventually moved forward. The political uncertainty, again, was just California's initial climate authority came from AB 32, which gave authority to the regulator to operate programs like the LCFS through 2020. It was unclear whether that authority extended past 2020. So until SB 32 passed, which was 2016 or 17, it was unsure whether we would hit 2020, and then the program would either have to freeze targets and not go any higher, or perhaps even go away entirely. Either way, that would have suggested a very little incentive for additional deployment of clean fuels. And so that would have sort of indicated there wasn't an incentive, really, there wasn't a sufficient or a significant incentive to be had in those cases.
So it's fair to say a lack of policy certainty can disincentivize investments in clean fuel projects?
Yes. Yeah. Again, companies know how to deal with some uncertainty, but the uncertainty of, is the program going to exist or not in any significant fashion, is enough to chill the market to some extent.
And companies may decide not to participate in a state's program if the policies or incentives aren't there, correct?
Yes, that's true.
Okay. I'd like to talk about kind of specific kind of policy certainty. Do explicit fuel pathways covering specific fuels provide policy certainty to regulated entities?
So in the programs that exist to date, most pathways are certified for 10 years. And that's to make sure that, a company that is investing in the production understands they can get at least 10, have some predictability about the amount of incentive they'll receive for every gallon or kilowatt hour or therm or whatever delivered into the market. So, yes, the existence of pathways, the typical expectation that pathways can be recertified as long as the underlying conditions haven't changed also adds to that.
And those programs list specific fuels and fuel types, correct?
I guess I don't quite understand your question, but yes, they list specific fuels.
Like under Tier 1, there's a list of fuels that qualify as Tier 1.
Yes, in most programs, tier one are fuels that are very well understood. There's a long track record of empirical data, and a producer is going to have relatively, kind of small variations from each other. Corn ethanol in most cases comes in through a tier one pathway because it's a very mature technology, and the differences between different producers are relatively limited. If it requires sort of less scrutiny or review because the technology is understood and because it's not so different than the others. If you have a situation where the technology is more novel, or they're adopting a production process that varies from others, then you might get into a situation where a tier two pathway is required.
Let's talk about tier two. So it's your understanding that tier two is, well, here, let me ask you the question. What are tier two fuels typically?
Typically, in most other programs, again, they're fuels where the production process is either not as well not quite as mature. Not to say it's totally understood. Mm-hmm. There's a lot of certainty involved, but there's not as extensive a track record, or there are a greater degree of case-by-case variations between fuel producers based on local conditions or the configuration of the production facility. So tier two pathways are a bit less of a kind of a template where you just fill in a few relatively straightforward production numbers. There's a bit more scrutiny and evaluation involved in those pathways.
And I think I heard earlier you mentioned that tier two also covers fuels produced using different production methods or innovative production methods.
Most commonly, yes. Programs have different ways to bring them in. There are also some places that will have provisional pathway types to bring them in. Them being, fuels that use a novel or less understood. Sorry, not less understood, but a pathway with a shorter empirical basis.
And states like California provide kind of a catch-all pathway under tier two for fuels produced using innovative methods, correct?
I don't know if this is call it a catch-all pathway. There are provisional pathways that are meant to be kind of conservative expectations that will allow a fuel to at least enter the market and start developing credits and let the producer move into production. But they're always done on a case-by-case basis. At the very least, there's an evaluation of whether a given provisional pathway is appropriate for the use of that fuel in that case.
And let me rephrase the question. Does California provide a pathway under tier two for fuels produced using innovative methods?
Objection, Madam Hearing Officer. This line of questioning is delving deeper than the scope of Dr. Murphy's testimony.
All right. Mr. Tucker?
My understanding is Dr. Murphy is, testifying as an expert on low carbon fuel standards. So I'm just trying to understand his familiarity with those programs, what other programs are doing.
All right. So, Dr. Murphy, if you have an answer, you can offer it, and then we do need to break for lunch. And thank you for helping optimize our time here.
There is a project crediting pathway for innovative crude. I'm not sure that the word innovative is applied to a category of pathways. It's possible that it is. My suspicion is that it would be more. It is used as kind of a qualification if a fuel is seen as being innovative. So I don't know to what extent the word innovative has specific legal or regulatory or programmatic meaning, as opposed to being sort of a general description.
You mentioned innovative crude. Can you tell us what you mean by that?
In California, an innovative crude pathway is the use of things like solar steam production rather than natural gas steam, or other renewable energy at the crude oil production site.
Are there any other examples of innovative crude?
In some cases, the use of captured carbon dioxide they would fall under the innovative crude provisions. I do not believe any of those have been certified in California yet.
would crude oil produced using carbon capture through direct air capture
Yes, that would
fall into that category as well?
Yes, but again, I don't think it. But none of those. Certainly, there are no. Certainly, none of those pathways have been certified to date. But when the technology is online, yes, that is the provision that they would likely come in under.
Mr. Tucker, we're going to have to pick this up
Okay.
after lunch.
Thank you very much. I'll pick this up after.
1 o'clock, please. My name is Felicia Orth. We're on day 2 of the hearing in EIB 2523. This is the Clean Transportation Fuel Program rulemaking. This is one of many opportunities to offer non-technical public comment. We didn't have anyone reach out to say they desired this slot, but I issue an open invitation regardless. Is there anyone in the room here to offer public comment during this session? There will be many other sessions. Okay, I don't see a hand. Is there anyone on the platform who is here with us to offer public comment? And oh, Lisa, I'm sorry. Ms. O'Grady, if you would, please.
Nada más para saber si hay alguien aquí presente en el auditorio que quisiera hacer un comentario público, si puede avisarnos, por favor. Y igual en la plataforma, si hay alguien en la plataforma que quisiera hacer un comentario público en español, si nos pueden hacer el favor de dejarnos saber. Gracias.
Thank you, Ms. O'Grady. Now, is there anyone on the platform who would like to offer public comment at this time? No? All right, Pam isn't seeing any hands there. Thank you all. Then we'll go back to the technical case and bring the Environment Department panel back. The next opportunity to offer public comment will be 1 p.m. tomorrow. That's 1 p.m. Wednesday. Hold on 1 second. Oh, you want this?
No, the feedback.
Oh, there was feedback? Oh, I'm sorry. Do you still hear it? Still now? Nope, that's good. All right. So Mr. Tucker is the interrogator at this point, and Mr. Tucker, you were about 12 minutes into your questioning of Dr. Murphy.
Thank you, Hearing Officer Orth. Again, for the record, Aaron Tucker on behalf of Oxy USA. Good afternoon, everyone. Thanks for being here. Dr. Murphy, I'd like to kind of continue your testimony that we started before lunch. I'd like to move on from fuel pathways. On page 14 of your testimony, you mentioned project-based credits. In addition to fuel pathways, this is a second way that credits can be generated under a clean fuels program, correct?
It's another way. Second, I don't know if that implies priority, but yes, it is another way to generate credits.
One of the ways that credits can be generated. Okay, thank you. And what is your familiarity with project-based credits?
So the programs in California and Oregon have project-based credit opportunities. They encompass a number of different project types, including refinery improvements, crude oil production. There are the infrastructure capacity credits are sort of within the project-based credit categories. They are usually used for areas where you don't have an obvious flow of fuel to use as the basis for generating credits, but you clearly have reductions that are within the transportation fuel system. So they sort of allow those to be integrated into the clean fuel standard framework.
You mentioned reductions there. Are you aware that New Mexico statute also requires project credit opportunities for removals?
Yeah, I recall reading that. Yes, I recall reading that.
And does California's LCFS program specifically address project-based credits for carbon capture and sequestration?
So there is a protocol for carbon capture and sequestration to be used as the basis for crediting in California. Those can come in either through project-based credits, or if there's a CCS opportunity integrated into a fuel production pathway, it could also be used to reduce the CI of that pathway. But yes, there are opportunities for CCS to be integrated. As I said before, I don't think any projects have actually utilized those at this point. But the opportunity is certainly there.
And just to clarify, so under the California program, CCS is can be used both through a fuel pathway and a project-based credit.
Yes.
Okay. And the rules specifically address, you mentioned protocols, but the rules specifically address carbon capture and sequestration, correct?
Yes, the protocols are largely about things like site selection, monitoring requirements, post-injection monitoring requirements. Essentially, how do you effectively quantify the amount of carbon that is being put underground? How do you ensure that it is not causing environmental problems? There are issues relating to like a buffer account in the event that there is a leakage or some reversion.
Thank you. Earlier we talked about policy certainty. Do you agree that New Mexico's clean fuel program would provide greater policy certainty to applicants if it explicitly listed qualifying types of project credits, such as CCS?
Objection, Madam Hearing Officer. As with the prior party questioning, we established that Dr. Murphy's testimony scope is broad spectrum on the other programs, not specific to his opinions on New Mexico.
Right, Mr. Tucker, that is what we established earlier.
Okay, I'll rephrase the question. Do you agree that a clean fuels program generally would provide greater policy certainty to applicants if it explicitly listed qualifying types of project credits, such as CCS?
In general, yes. It takes time to develop all these different, sort of protocols and pathways. It was a long process in California to develop the CCS protocols there. So, given the time frame, it seems reasonable that certain parts of it, especially technologies where we haven't actually seen any deployment in the jurisdictions that already allow it, might be left for future work.
But do you agree that states can develop rules based on the lessons learned in other states that have already implemented these programs?
Yes, they can.
Thank you. That's all the questions I have for Dr. Murphy right now. I'd like to move to Mr. Vaughn. Good afternoon, Mr. Vaughn.
Good afternoon.
My understanding is your testimony focused on kind of the public participation, including the advisory committee process, correct?
That's correct.
Okay. And can you just briefly describe your involvement in the advisory committee?
Sure. My involvement with the advisory committee began essentially in April of 24 when we kicked off the rulemaking effort. Obviously, the first thing we did was implement the requirements of the statute to have an advisory committee. So beginning in that process, we, as I have testified to in writing, We sent out communication letters to several parties, several companies who might be interested in applying. We also sent out a press release calling for people to join the advisory committee. So my involvement was partially helping to get those announcements out to the public and to those companies and entities. My involvement went on to help collect the applications that we received. If I recall correctly, we received approximately 65 applicants. And my involvement also included initially reviewing those applications, looking at the expertise of those applicants, and sort of helping to focus the structure of the committee to the secretary. Ultimately, the secretary made the selections to the advisory committee. Beyond that, I helped administer the advisory committee meetings, including complying with the Open Meetings Act, issuing announcements, agendas, meeting minutes, meeting recordings, making those available to the public. And ultimately, I worked closely with one of my colleagues to help compile the input that we received from the members into the technical report.
So you're familiar with the contents of the advisory committee report, is that fair to say?
I am pretty familiar with it, yes.
Okay. And as part of your role with the advisory committee, did you help review those responses and respond to the comments and concerns raised?
I'm not sure I understand the question. Could you be a little more specific?
Let me rephrase. Sure. As part of your responsibilities, did you review the comments and concerns raised in the advisory committee report?
Yes.
Okay. Did you, as part of your role on the advisory committee or as part of your work, did you help respond to those comments and concerns in the rule development?
Yes, as I testified yesterday, we took several of the recommendations from the individual members. We took those, as I said, to other states. We took those recommendations to, California, Washington, and Oregon to try and understand how those recommendations might affect their programs and in turn our own. So in that regard, yes.
All right. Thank you. I'd like you to turn to NMED Exhibit 36, Bates number 4.
I do not have an entire copy of the technical report in front of me. I might ask my counsel to supply that so that I could get on the same page with you.
Sure, and maybe I can just, are you familiar with the list of advisory committee members?
I am.
Okay. Did members of the oil and gas industry participate in the advisory committee?
They did.
Okay. Did Occidental Petroleum or Oxy participate in the advisory committee?
I would have to double check the list to be sure about that, but I know that it is in that exhibit for sure.
Okay.
Including the affiliations of each member.
So you testified that the list represents who was participated as a member.
That's correct.
Okay. And I'll just represent that Oxy was a member of that committee.
Thank you.
All right. Do you agree that that industry as the regulated entity has a valuable perspective to share in the rule development process?
Yes, I believe that the producers, importers of transportation fuel who are regulated by this rule have valuable input on how the rule is shaped.
Why do they have a valuable perspective?
Well, the proposed rule would regulate those entities in this very specific scope that they operate in. So, of course, their input is valuable.
And do you agree that with respect to clean transportation fuels, regulated entities have experience with these programs in other states?
Yes, some of the members who were on the advisory committee included parties that may be regulated in those other states' programs.
And that experience from other state clean fuels programs could provide valuable insights into the rural development. Into the rural development of a clean fuels program here in New Mexico?
I would agree.
Okay. What were the key?
Mr. Tucker, sorry, I'm behind you. We can provide that exhibit if you have further questions that will necessitate the witness looking at it.
Oh, thank you, Ms. Sona. I think we're good.
Okay, thanks.
What were the key concerns raised by the oil and gas industry to the Clean Transportation Fuels Program in the advisory committee?
I would simply refer you and the board to review the technical report, which includes many of those concerns. In fact, I would say all of the concerns that were raised by the oil and gas industry.
But you can't recall any of the key points or key concerns?
I have testified to them in my written testimony, to several of them, not all of them.
Can you point to us where in your testimony we can find that?
This would be NMED Exhibit 34, beginning on page 5, Section 3, the Inaugural Advisory Committee.
And looking at that testimony and reviewing it, does this refresh your memory on any of the key concerns raised by the oil and gas industry?
Well, I would encourage you to ask a specific question as opposed to whether or not I recall all of the oil and gas industry comments that were provided in the technical report.
I'm just asking, generally, what were the key takeaways from the process?
Again, I would refer you, so that I don't inadvertently leave content out, I would refer you to the report itself.
Okay. Well, earlier you testified that you were deeply involved with the advisory committee process, reviewed that feedback, and responded to it. And you can't recall a single topic that was raised?
Madam Hearing Officer, objection.
How is the question objectionable?
It's the manner of questioning. We're getting into the territory of beginning to harass and intimidate the witness, requiring him to recall a vast amount of facts is unreasonable.
Well, the question I heard was, could you name a few of the key takeaways? That was the question I heard from Mr. Tucker. And I guess I didn't think that was an objectionable question. Mr. Vaughn, do you remember?
One of the items that comes top of mind is the recommendation by some members of the oil and gas industry to essentially kickstart the program with a reporting only period.
Thank you. But there were other topics raised by industry during the advisory committee process, correct?
Of course.
Okay. Did members of the advisory committee raise kind of comments or concerns about credit opportunities?
I believe so, yes.
Okay. Did committee members suggest that the rule provide credit opportunities for carbon capture and sequestration?
Yes, I do believe some members included those recommendations.
Okay. Did committee members suggest that the rule provide credit opportunities for direct air capture?
I believe so.
Okay. In December of 2024, NMED released the discussion draft.
Yes.
Correct. Okay. How did NMED incorporate the advisory committee's recommendations on credit opportunities for carbon capture and sequestration into the discussion draft.
For carbon capture and sequestration specifically?
Specifically, yeah.
I don't believe there were opportunities in the discussion draft rule, but of course there are opportunities under the project crediting section in the revised proposed new rule.
And I'll get to that later. But did NMED incorporate advisory committee comments on direct air capture into the discussion draft?
Can you restate the question, please?
Sure. Did NMED incorporate comments raised on credit opportunities for direct air capture into the discussion draft released in 2020?
The answer is the same. I don't believe so in
No.
the same regard as CCS.
And Mr. Vaughn, were you involved with compiling and responding to the comments that were raised on the discussion draft?
Was certainly responsible for compiling that information into the technical report, and to the extent that I described earlier, responding and that we took that information to other states to understand how it would fit into this type of program, yes.
And sorry, going back to the advisory committee process, did NMED receive comments during the advisory committee process that the rule provide alternative fuel paths for fossil fuels produced with a lower CI?
I don't recall.
Do you have a copy of Exhibit 36?
That's the same copy that you asked for a moment ago.
I apologize to council and the board. As the Environment Department, we tried to save paper. This is a very long exhibit. Mr. Vaughn now has it in front of him on the computer, and that's the only thing he'll be looking at.
Thank you very much. Mr. Vaughn, would you mind turning to or scrolling to Bates 53?
That was, just to clarify, page 53 of 88.
It's the Bates in the corner.
Got it.
So 00053. Let me know when you're there.
Okay.
Could you look towards the middle of the page? There's one labeled D, starts with allow fuel producers.
Yes, I see it.
Okay. Would you mind reading that comment?
D, allow fuel producers, both fossil and alternative, to apply for a lower CI if they have incorporated innovative ways of reducing the carbon footprint of the fuels they are producing. Do not require use of the lookup table or calculators if a producer wants to develop a fuel pathway / life cycle analysis specific to their fuel.
Great, and I'll have you stop there. I'll ask you the question again. Did NMED receive comments during the advisory committee process requesting that the rule provide alternative fuel pathways for fossil fuels produced with the lower CI?
I would say based on this comment, that's pretty likely, yes. It's not exactly what that statement says, but it's pretty close.
Okay. Well, is there something in my question that makes you say no?
No.
Okay. So you would agree that the advisory committee received comments requesting fuel pathways for fossil fuels produced with a lower CI.
Madam Hearing Officer, objection that these have been asked and answered, and the evidence speaks for itself. It's not effective to have the witness characterize the documents.
All right, thank you. I think you did ask him that twice now.
Yeah, I was just trying to get certainty on the answer there and trying to clarify why there was hesitation.
Okay, thank you.
Thank you. I'll move along. How did NMED incorporate the comment and concern raised above into the discussion draft shared in December?
By above, do you mean paragraph D there?
Sorry, yeah, that we just discussed.
And you asked specifically about the discussion draft?
The discussion draft.
As I've stated earlier, I do not believe that we incorporated this specific recommendation into the discussion draft rule, but I do agree that this has been incorporated further into the petition rule.
Can you tell me where you think that's incorporated?
I would defer that question to Ms. Borchurch.
Okay, thank you. I'll ask her later. So in response to the discussion draft, or as part of the discussion draft, NMED requested and received comment on the discussion draft, correct?
Yes.
Okay. Did NMED receive comments from Oxy on the discussion draft?
I believe we did.
Okay. Did, and if I could ask you to turn to Exhibit 37B.
This would be the input.
This is the comments received on the discussion draft.
Okay. Is there a specific page?
Let's start at, I think, 141.
Is that Bates 141?
Yeah, Bates 141.
Sure.
Are these,
This being the draft meeting minutes, I just want to confirm.
I'm sorry?
This being the draft meeting minutes?
This is 37B, Exhibit 37B, the comments.
One moment. I was on 36.
Oh.
I apologize. I don't know that I have that up. Again, I might have to ask my counsel to pull this document up.
That's fine. We can just take a second. Thank you.
Council, we will get that pulled up for Mr. Vaughn. It is another lengthy document. However, I would preemptively object, I guess, if this line of questioning is the same as the last. It's really not effective for the board to force Mr. Vaughn to characterize testimony that's or characterize evidence that's already explicit in the record and speaks for itself.
Yeah, Mr. Tucker, I am wondering about the utility of this. If it's in the record, it's in the record. And
yeah, I'm just trying to, well, I'm trying to understand, to get insight into the public participation process and to see how NMED responded to comments raised on specific issues.
okay, so perhaps to speed this along, you could ask him to assume that Oxy submitted a comment.
Sure. Yeah, I can move it along.
All right.
Yeah, that's fine. Do you recall that Oxy submitted comments to NMED requesting that it provide credit opportunities for direct air capture in CCS?
Yes, I do believe that's correct.
Okay. And what did NMED do to respond or to incorporate those comments into the rule?
Again, I believe those are incorporated into the project credit opportunities that are in the petition rule.
Is your understanding that does the rule specifically address either of those types of project credits?
Objection, Madam Hearing Officer. Mr. Vaughn already testified that the ins and outs of what's in the rule are testimony best served by Ms. Borchert.
I remember that.
All right, I'll move along. One last question. Do you recall comments from Oxy on the discussion draft requesting that the rule provide a fuel pathway for innovative crude oil?
I believe that's correct.
Okay. And questions related to the incorporation of those comments or lack of incorporation who should those questions be directed to?
Again, I believe those could be directed to Ms. Borchert.
Okay, thank you. That's all I have for you, Mr. Fung. Thank you. Good afternoon, Ms. Borchert. Am I saying that right?
Yes.
Okay, thank you. So I'll start by kind of asking you those questions. During the advisory committee process and on the and comments to the discussion draft, concerns were raised about credit opportunities for carbon capture sequestration and direct air capture. How did the NMED respond to those questions or comments? I'm sorry.
Right. Well, can you, okay. All right. I want to just, respond is kind of a strange word in that context. I would feel comfortable testifying about how we considered them.
Okay. How did NMED consider those? Let's start with how did NMED consider those comments?
Well, we said check. Oxy's request for project credits, be it of any kind, CCUS or DAC, direct air capture, is included in 306 project credits.
But the project credit section doesn't specifically mention direct air capture, does it?
It does not. It also does not specifically not include them.
And Section 306 doesn't specifically mention carbon capture and sequestration, does it?
And I would give you the same answer. You're right. It does not specifically include it. But when I was thinking about this section, I was thinking it incorporated both.
Okay. Well, let's talk about that. So in your testimony regarding Section 306 for project credits, you state that project credits meet the program objective of reducing the GHG emissions for transportation fuels consumed in New Mexico outside of an alternative fuel pathway. When you refer to program objectives, you're talking about the statutory directives in House Bill 41, correct?
Correct.
Okay. And yesterday, Director Miano testified that Section 4C3 of HB 41 requires the rule provide credit opportunities for reductions and removals. Correct? Or do you agree?
Yes.
Okay. So you agree that the final rule requires there be additional credit opportunities for both reductions and removals?
Yes.
Okay. Can you explain the difference between a reduction and a removal?
Objection, Madam Hearing Officer. Director Miano testified to this exact question.
Okay.
And yesterday, council objected to that and asked us to direct those questions to Ms. Borchert, and now I'm directing those questions to Ms. Borchert.
Is that true?
Perhaps withdrawn. My apologies,
Thank you.
Council.
Thank you.
It's Borchert. Yeah.
Borchert, I'm sorry. Ms. Borchert, can you please explain the difference between a reduction and a removal?
Yeah, removal is usually the removal of carbon dioxide by some mechanical means. Reduction is a much there's a broader variety of ways you can reduce greenhouse gases versus versus removal.
Can you provide us an example of a removal?
Yeah, I can kind of speak to this, but there's a group, I think it's called Infinium, that is setting up shop in just north of here in Nambe Pueblo, that I think is using ceramic media that passively take carbon dioxide out of the air and store it into this ceramic media. That's an example of removal.
Yesterday, Director Miano testified that direct air capture is a type of removal. Do you agree that direct air capture is a type of removal?
Yes.
Okay. Does the rule define removals?
Oh, I'd have to check into our definitions. I will be happy to do that. Removal. Alphabetical order, section 7. Remove. It does not.
Does the rule define reductions?
Seems so elementary. I doubt that we would define a word like reduction because we try not to define things that are commonly used in the American dictionary sense.
And just to clarify, or just to review, the rule doesn't define reductions, correct?
Asked and answered.
No. Does it?
No, it doesn't.
And it doesn't define removals.
She's already said that.
Okay. So, and the project credit section doesn't list any type of reduction or removal that could qualify.
Are you asking whether?
Sorry, going back to the project credit section, the rule doesn't identify any types of projects that might be eligible.
I think I just answered that question, but I don't believe it does. I'd have to go back and look. It does say reduce. It does say reduce and remove. I don't know if you noticed that.
It does say reduce or remove. I agree, but it doesn't list any types of projects or activities that qualify.
Correct.
Okay. Looking at the heading of section 306, or can you tell me what the heading of section 306
is? It says project credits for the reduction of greenhouse gas emissions. And I would also, if you want to go to headers.
Hold on. No, I'd just like you to answer the question. So,
I would like to qualify my answer.
So,
because
the question was just, what is the heading of section 306?
Okay, I will read that. Project credits for the reduction of greenhouse gas emissions.
Does this heading address removals?
I do feel like I need to explain that
it's a simple question.
It is a simple question.
Mr. Tucker, let her give a complete answer.
You may not know that in New Mexico, we have a very particular detail about that's part of our state that dictates the regulations. It's section 14 that says construction of headings. And what construction of headings particularly means is that both the headings as in bold, but also the other headings that are titles of sections and titles of subsections do not inform the content of what the rules say. They're not meant to be interpretive.
That may be true, but my question was, does the heading address removals?
No.
Okay. Would the rule better implement the statutory directive to provide credit opportunities for removals if it also listed removals in the title?
Objection, Madam Hearing Officer. We've addressed the importance of titles. This witness has testified about these.
I think she's already effectively answered this.
Okay, I'll ask you a different way. Thank you. Would the rule provide greater policy certainty for regulated parties if the title reflected that credit opportunities are available for reductions. I'm sorry, for removals.
Objection, Madam Hearing.
Again, Mr. Tucker, she's already given you her answer as to the weight or impact, the meaning of a heading on the content of a provision. I don't know that there's any more to say about that.
Okay, I'll move on. Okay, so we talked about that the Section 306 doesn't identify any project types. Can you explain why?
As a general rule, we try not to do an including ... because exactly to your point, then somebody who has a different kind of removal methodology or a different kind of CCUS or a new version that'll come out in 6 years that is yet something different. If we haven't put it in the including language, then people are concerned that the language that I think stands on its own isn't inclusive of that when we are intending it to be inclusive of projects that reduce and remove greenhouse gas emissions.
Does a lack of specific examples result in a lack of, does not including specific project types result in a lack of policy certainty for regulated entities about what may qualify?
Objection, Madam Hearing Officer. This has been asked and answered.
Well, and it's asking her to read the minds of the regulated entities. I think that might be better coming from the lips of a witness for the regulated entities.
Well, I'm just trying to understand the basis for the rules that NMED has
But that
drafted
wasn't
at this point.
I'm sorry, that wasn't the import of your question, though. I think you were asking a question from the perspective of the regulated entities, whether they would feel more certainty if the rule were different.
Correct. And one of NMED's witnesses testified about the importance of policy certainty. And so I was trying to understand from the subject matter expert how they incorporated that into the draft rule, or how they considered it.
Okay, and I think that's a perfectly good question.
How did you consider may she answer my question, or do I need to rephrase it?
How did she consider policy certainty when writing that section of the rule?
Correct. How did you consider policy certainty when writing that section of the rule?
Well, I think that a previous NMED witness spoke at a different level of policy certainty, which was more about what's happening at the state level with the regulations. What I would say about that is the policy certainty is in the statute, right? The statute is very clear, as you pointed out earlier, C3. And if there ever were a question for anybody about policy certainty and it was laid out in a statute, it doesn't seem like there would be a lot of question as to the policy direction.
Well, I think let's talk about those questions. So yesterday, Director Miano mentioned the department would provide guidance to fill in some of the gaps in the regulation. Correct?
Correct.
Okay. And it's your understanding the department will provide guidance to fill in some of the gaps in the regulation after this rulemaking.
Correct.
Okay. Has the department determined what topics it will be issuing guidance on?
I'd like to have you please direct that to Dr. Rosso.
So you don't know what topics the department intends to issue guidance on?
Objection, Madam Hearing Officer.
She's given you the name of a better witness to address it.
If I may, can I ask one more question on this? Does the department intend to issue guidance related to project credits?
That too is a better question for Dr. Rosso.
Okay. NMED has made some changes to the project credit section since the petition draft. What were those changes that NMED has made?
There's a red line version in Exhibit 2. Would you like me to read all of the added language?
Could you just summarize the key points?
The key points are that it changed the date of when project credit applications were being accepted. It's brought it earlier in time. It used to be January 1, 2030, and now it's July 1, 2026.
Okay.
Are you guys still getting feedback?
It's harder to hear.
Do you want me to keep testing? Or?
Hold on 1 second. Is that better? Keep speaking now.
Test.
That's okay for me.
No, I can still hear I can hear the ringing.
Oh.
Test.
Yeah, fine. Thank you. Sorry, I'll add a minute to your time.
Okay.
Sorry for the interruption, Ms. Borcher.
No, the problem with this one was Let me bring you another.
And the second change, there's a second change is the providing a provision by which a project credit applicant pays the fees for submitting an application, and also the requirement that the department make sure that project credits that are awarded do indeed reduce the emissions, verify that the emissions are reduced as anticipated by an application.
Okay, so there were just to summarize, there were 3 key changes. The date was moved up. The addition of project fees for project credits, and a clarification that the reductions needed to be verified.
Correct.
Does MED need to, does that verification also cover removals?
I guess in my mind, removal is like an end member of the spectrum of reductions. So in my opinion, yes.
So earlier you testified about the difference between reductions and removals, and now you're saying they're the same thing?
I'm saying projects that remove are different than projects that reduce, but the end result of whether greenhouse gas emissions are reduced by one means or another is still going to be the end result. That doesn't necessarily bear a distinction when you're not talking about projects.
Okay, so moving to one of the other changes, why did NMED move up the date from 2030 to 2026?
Objection, Madam Hearing Officer. This has been already addressed at length by Director Miano.
I do remember that, Mr. Tucker.
And yesterday, council objected and asked us to direct those questions to
Ms. Borchard again?
Ms. Borchard, and again,
Okay.
I'm asking her.
Thank you.
So the question, could you repeat the question, please?
Why did NMED move up the date from 2030 to 2026 for the project credits?
we had so many considerations about what to put in our first rule to set up this program. And we were concerned about adding complexity to our program that we may not be able to handle, along with all the other complexities that are required to get a project up and running. And so I think initially we thought this is a valued part of the program. We're just not sure we can do it now. And after reconsidering that, we decided it was valuable enough to incorporate sooner rather than later.
And the reason NMED decided that they could do that was because by adding project fees for project credits, correct? That was part of the...
Objection, Madam Hearing Officer. Council's question reveals the very fact that Director Miano testified to the specifics of this. Now, if there's nuanced questions remaining about the testimony that Director Miano offered, Ms. Borchert would be the appropriate witness. However, we have a lot to cover. Similar witnesses are covering a lot of testimony, and council needs to direct their questions to the right witness.
All right, Mr. Tucker.
Once again, council yesterday objected to those questions regarding project credits and asked that we direct the questions to Ms. Borchert. I'm directing my questions to her.
Okay, again, to the extent, Ms. Borchert, that this is within the scope of your testimony, go ahead.
Madam Hearing Officer.
Yes.
If I may, to characterize that council has offered a different witness is inaccurate. If Director Miano has offered a different witness, that may be a fair characterization.
All right, thank you. Go ahead, Mr. Tucker.
NMED determined that they could administer the project credit section earlier based upon having fees to cover the project credit section. Is that correct?
It's one of the multiple factors. I would say another big factor is that, we, as many have said here, have been at this since April of 2024. So now that we are here, and let's say, August, 14 months after we started, we had started to feel like we understood what it would take to set up the basics of a program. And adding on another component didn't feel as daunting as it might have in December or even in May.
Thank you. Last question. Is NMED considering any other changes to the project credit section?
I guess that's a very big question.
If I may, Madam Hearing Officer, objection. Council is asking the witness to characterize what may be rebuttal testimony, and I think that's unfair at this point.
I think the parties may well be refining their positions or their proposals as part of rebuttal, which we'll hear the week of November 17th.
Okay. Let me rephrase that. Has NMED finalized its changes to the project credit section?
Again, Madam Hearing Officer, as testimony has revealed, this hearing may well reflect that additional changes will be made. That is not a fair question to put the witness in to answer.
Right, because then she's saying on November 17th, there won't be any changes. It goes to the same question. Okay. Do you have other questions?
Then I'll move on. Thank you.
Thank you.
All right, I'd like to move to Dr. Rasso. Is that right?
Yes, that's correct.
Right, thank you. I'd like to turn to fuel pathways and the development of the rules governing fuel pathways and carbon intensity. Your colleague, Mr. Vaughn, testified that NMED received comments during the advisory committee process requesting that the rule provide fuel pathways for fossil fuels produced with a lower CI, correct?
I believe he said that, yes.
Okay. And your colleague, Mr. Vaughn, also testified that MED received comments on the discussion draft requesting that the rule provide pathways for fossil fuels produced with a lower CI, correct?
I believe he said that.
Okay. In your oral testimony yesterday, you stated that fossil fuels must use the lookup table. Is that correct?
That is correct.
Okay. Stated otherwise, fossil fuels produced with a lower carbon intensity may not apply for a fuel pathway under Section 205.
The list, sorry, 1 second.
Okay.
The list of fuels that must use the lookup table is in section 201A1, and that's clear gasoline or fossil gasoline blend stock, clear diesel or fossil diesel blend stock, fossil natural gas, and fossil LPGs. LPG.
So just to say that, so fossil fuels produced with a lower carbon intensity may not apply for a fuel pathway in Section 205?
The fuels I just listed, which included fossil fuels, cannot apply for an alternative fuel pathway.
Okay. Therefore closed from applying for a pathway.
They must report using the lookup
Okay.
table values.
So is it fair to say that NMED rejected comments to provide a fuel pathway for fossil fuels produced with a lower CI?
I think it would be fair to say that NMED chose to require those fuels to report using the lookup table pathways. Report using the lookup table pathways.
The statute requires the rule be technology neutral, correct?
Correct.
Okay. Does MED's decision to exclude fossil fuels from a pathway, from the pathways in Section 205, violate the statutory directive for the rule to be technology neutral?
I don't believe so.
Why not?
Madam Hearing Officer, this line of questioning is calling for a legal conclusion. Interpretation of the rule and implementation is different than whether or not there's a violation of the statute.
All right. Dr. Resso may be able to provide her perspective as one of the rule drafters. I would just caution you, Dr. Resso, not to offer legal analysis or opinions.
I would consider that the framework of a Tier 1 and Tier 2 pathway applications already considers how well characterized fuel production processes are for different types of fuels. And the lookup table is a Tier 0 within that framework, or similar to a Tier 0 within that framework, where fossil fuel production methods are well characterized.
Do you agree that fossil fuels can be produced with differing carbon intensities?
I believe I stated in my testimony earlier that the greenhouse gas emissions from fossil fuel production are heavily dependent on the crude oil sources, which would lead to that conclusion.
So if the sources are different, then the CI can be different.
Yes.
Okay. And NMED took that fact that the carbon intensity of crude oil sources is different into account when they selected New Mexico specific parameters for the GREET model.
We took into into account that different regions of the country, including New Mexico, have different sources of crude oil.
And I believe yesterday in your oral testimony, you said that was because the carbon intensity was different. Is that correct?
I believe I said that the greenhouse gas emissions from production is different depending on the crude oil sources. Yes.
Okay. So on page 15 of your written testimony, you state that due to the interconnected nature of fossil fuel gathering, I'm sorry? Okay, I'll speak slower and closer to the mic. Is that better? Okay. On page 15 of your written testimony, you state that due to the interconnected nature of fossil fuel gathering, refining, and distribution, and limited public data availability for individual fossil fuel streams, there is no viable way to determine and verify exact production, transportation, and storage emissions for individual fuel streams. Is that a correct? Is that your testimony?
Yes.
Okay. Is this the stated reason for why the rule excludes fossil fuels from applying for a fuel pathway?
That is what I've stated in my testimony.
Okay. Have you ever prepared an application for a fuel pathway in a state with an approved clean fuels program?
I have not.
Okay. Have you ever prepared a life cycle analysis for a fuel pathway application in a state with an approved clean fuels program?
I have not.
Have you ever worked in fossil fuel gathering, refining, or distribution?
I have not, but in my work at the department, I have done significant work in evaluating the emissions at various points in the fossil fuel system.
But you didn't work in the industry, is that correct?
That's correct.
Okay. Does the rule require fuel pathway applications to rely on publicly available data?
It does not.
Okay. Can an applicant rely on non-publicly available data to calculate and verify a fuel's carbon intensity?
They can.
Okay. Thank you. Or actually, I'm sorry. Ms. Rasso, I'd like to turn to guidance. You were designated as the expert on, or the testifying expert, testifying witness on guidance. Is it your understanding that the department would provide guidance to fill in some of the gaps in the regulations?
Yes, we intend to issue guidance on implementation of these rules.
Has the department determined on what topics it will be issuing guidance?
I don't know that we have a complete list. I have an ongoing list of topics that we will need to release guidance on.
Can you provide us with some of the topics that you're planning to?
Boy. So I have a list of at least 50 topics that will have either user guides, guidance, standard operating procedures for staff, forms. That would include everything from, as I believe Ms. Borchert talked about, how do you pay your invoice, to things like what information do we expect to see in alternative fuel pathway application.
Has the department mapped out a timeline for issuing guidance?
Not formally. I have considered that list of 50 items are the items that I believe need to be ready before the effective date of the rule.
And what is the effective date of the rule as proposed?
As proposed by the department, it's February 1st. As Ms. Borchert said earlier, we realized that that may not, in fact, be the effective date.
Does the department intend to issue those 50 guidance documents released before February 1st?
We intend to release them before the effective date of the rule.
So earlier you mentioned that the effective date was February 1st. Are you planning to release all those guidance documents by February 1st?
Objection, Madam Hearing Officer. This question harasses the witness. She gave a fair answer, and whether counsel likes the answer or not, she answered the question.
I don't think she did, actually. She said they plan to release the guidance before the effective date of the rule. we're not sure about the effective date of the rule. It was proposed for February, maybe now April, maybe July. And he's asking specifically, do you intend to release the guidance before February 1st?
I think some of those guidance documents will be released before February 1st.
Some, but not all.
As I said, that list of 50 documents includes things like forms and standard operating procedures.
Mm-hmm.
So I anticipate that the guidance documents that would be vital for the regulated community to be effective on February 1st to be released. Some portions of those, or some guidance of those guidance documents, are not necessary by February 1st. For instance, we're not accepting alternative fuel pathway applications until July 1st of 2026, which is also, I believe, the date for project credit applications. I do understand that those need to be released in advance of the date that we're accepting applications, or else the regulated community couldn't reasonably be required or expected to conform to what is in the guidance.
So you mentioned project credits. Does the department intend to issue guidance related to project credits?
That is one of the items on my list.
Okay. Will that guidance address the eligible types of projects?
I'm not sure.
Okay. Will that guidance address application requirements?
Probably.
Okay. Do you think that guidance is necessary to develop applications?
I think that if the department does not release guidance in advance of the application date, we will receive a wide variety of levels of information and applications that will make it difficult to evaluate them.
So let me ask you about that. Before guidance is issued, do project credit applicants have certainty about what type of types of projects are eligible for credits?
As Ms. Borchert testified to, I think they have the level of certainty that is in the enabling statute.
Just in the statute?
The statute and the rule.
Okay. Has the department assigned the development of guidance to any specific staff members yet?
We have begun. So several of the guidance documents, for instance, guidance on how to register in the data management system, will be extremely similar to those guidance documents in other states. We have had some staff begin New Mexico-ifying them, so to speak, taking the Washington guidance documents and revising them to suit our program. We have also identified and are in the process of getting an experienced contractor on board to assist us with developing those guidance documents.
Does the department intend to reconvene the advisory committee to help with the development of guidance?
Objection, Madam Hearing Officer. Mr. Vaughn has testified to this, and I believe this was a subject he was comprehensive on. Perhaps I'm wrong. There's been a lot of testimony. I understand I've objected to a lot of this from council, so I apologize. But please just objecting in advance if these are not discrete questions that are different.
All right. So I thought Mr. Vaughn had been responsive to your question on this.
I was told to direct questions about guidance to Dr. Grasso. And so I'm just simply asking if there's any intention to reconvene the advisory case related to the development of guidance.
I see. It is more specific than.
Yep.
All right, go ahead.
I believe the role of the advisory committee is to provide input on the program and guidance document or program. I'm going to get my words wrong. Forgive me, it's been a long day. So the role of the advisory committee is to perform a periodic review of CTFP performance and provide input on whether adjustments are necessary. I would include guidance document in the category of CTFP performance.
So it's your understanding that the advisory committee could provide input, suggestions, comments on guidance?
I would expect the advisory committee, when convened, to provide input on guidance documentation.
Thank you. Okay, I'd like to just talk about one more topic, which is credit generation. So under the rules, credits are generated when a transportation fuel has a carbon intensity that is less than the applicable CTFS, correct?
Correct.
Okay. And we also talked about how credits can also be generated from project credits in Section 306.
Yes.
So it's fair to say that credits can be generated in two ways, by a fuel pathway or a project credit.
There are a few more ways than that, I believe.
Could you please explain?
So broadly speaking, there are two categories of credit. Credits, fuel credits, and the broad category of project credits, which I would include fuel supply equipment credits in the broad category of project credits.
Okay. And the broad category of credits, that's the defined term, right, in Section C18?
Sorry, C18 of the statute?
Oh, sorry, 20.2.92.7 C18 in the definition section. I believe it's page 3 of Exhibit 1, just to...
So are you referring to the definition of credit?
Yes, just the general definition of credit.
I'm sorry, did you want me to read it? I've lost track of the question.
Sure. Yeah. What? Let's see. Would you mind reading the definition of credit for us?
Credit means a unit of measure in metric tons of carbon dioxide equivalent generated when a transportation fuel with a carbon intensity that is less than the applicable CTFS is produced in New Mexico, imported into New Mexico, or dispensed for use in New Mexico.
Thank you. So we talked about how there's more than one way to generate a credit. Does NMED's proposed definition of credit address the fact that credits may also be generated for a project in accordance with Section 306?
The definition of credit does seem to be specific to transportation fuel.
Okay. So is that a no?
Could you ask the question again? I'm sorry.
Does NMED's proposed definition of credit address project credits in accordance with Section 306?
No.
All right. Does NMED provide a definition of project credits?
No.
No further questions. Thank you.
All right, thank you, Mr. Tucker. Is Mr. Wexler with us? Ms. Olson.
I just want to make sure. Remind me what exhibit they'll be thinking. Oh, no.
If you would introduce yourself first, please.
Yeah, just give me 1 minute.
Okay, good afternoon. Carrie Olson, representing American Fuel and Petrochemical Manufacturers. Good afternoon, everybody. Nice to meet you all. I'm going to start with a few questions for Dr. Murphy, and I'm going to try my best to not be repetitive of topics that have already been covered this morning, but I appreciate your patience as there's been a lot of questions. Okay, so just want to start briefly with the background of your testimony, starting on page 2. And you testify in that background that you were deeply involved in the 2017 to 18 rulemaking to amend the California LCFS. Is that correct?
Yes.
And your characterization of deeply involved, does that mean you were involved in kind of the drafting side of those amendments and the planning for that?
So I was working for an advocacy organization at the time, so obviously I was not involved in direct drafting of them. We made a lot of suggestions to CARB about them. We commissioned a modeling report. I was the project manager and a contributor to that, which was, I certainly think, perhaps showing some bias here, it was the most deep and comprehensive report on the topic made, and certainly it's a lot of the discussion centered around that. And because we had, among the kind of NGO community in California at the time, we had the most sort of expertise and resources, analytical resources brought to bear. We ended up being, I think, sort of central in a lot of the discussions among outside agencies. But no, we were an outside agency. We could make requests and ask for things. We had no direct role in writing the reg.
Okay. And were you involved in the underlying rulemaking or just the amendments piece of it?
Well, the initial rulemaking was in 2010 and earlier. I was still in grad school at the time, so no, I was not involved at that point.
Involved in that.
No.
In your experience in the amendment proceeding, it sounds like you did provide modeling and analytical data that was considered in developing that rule.
This is in the 2018?
Yes, sorry.
Yes, I mean, you would obviously have to ask CARB to what extent they considered it,
Sure.
But certainly based on the conversations we had with them, it certainly seemed like, yes, it was considered.
And I'm assuming that analytical modeling and data was specific to California to inform the California process.
I have to ask you not to step on each other's sentences there.
Sorry.
Apologies. Let's see. You weren't directly involved in the rulemakings or design of other state programs. Is that accurate?
Again, in all these situations, I've been sort of an outside participant, usually in a relatively informal way. In some cases, submitting comments on public dockets, and regulatory staff will sometimes approach us and ask questions because we're doing research on this, but we have no formal position with them. We don't draft any of the language directly.
So I'd like to just understand that testimony a little bit more. So it sounds like in the California amendments proceeding, you actually provided modeling and data.
Yes, we published 2 reports based on a model we developed at ITS Davis. Sort of analyzing the likely behavior of the market out through, I think it was 2035 or 2040. Really looking at the kinds of changes or provisions or questions that were being asked in the rulemaking process. So it was a technical modeling exercise, but one that was designed to be responsive to the questions being asked in California at the time.
And then in Washington, for example, did you play a similar direct role?
We had less engagement with Washington. We certainly had a number of informal conversations with them. We just didn't have the bandwidth to be as closely engaged or submit I think we may have submitted one comment on a public docket. You'd have to go back and look that up to be certain. But also, again, we have informal conversations where regulatory staff will often ask us, what the current science of something says, or have we evaluated one topic or another.
And based on your, I'll call it tangential involvement in that proceeding, are you aware of Washington specific data modeling, analytic data being provided to inform that specific rulemaking?
Not at a great level of depth. The challenge when you now have so many jurisdictions adopting similar but not identical versions of it is it's now impossible for me to be as deeply expert with all of them.
Sure. And I think I heard you say earlier this morning that there were about 6 states working on this. Is that accurate?
Yeah. The definition of what you call formal action, but if you include things like having a bill introduced or, sort of study or consultations with regulatory, somewhere around there, yes.
Going blind. And getting to your role in New Mexico specifically, when were you first hired by the New Mexico Environment Department or began consulting?
Let's see. The award was first issued, I believe, in September or October of 2024. There was a significant bureaucratic snafu on the UC side that prevented us from actually starting until, I believe, May or June of this year.
Okay. And so that was after the legislation was already passed?
Yes.
And is it fair to assume you had no involvement in the drafting of the New Mexico legislation?
Absolutely no formal role. A couple of conversations in an informal way in previous years. Okay.
And same with preparing the initial version of the draft rule, you weren't consulted?
Yeah, again, no formal role and only a couple of conversations.
And it sounds like things may have been a little bit muddy between the end of 2014 and recently. Did you have input on the draft changes and the iterations of the rule between the initial draft and what we're here on today?
I'm sorry, 2014?
I believe the initial draft rule was circulated at 2024.
Oh, okay.
Sorry. Yeah.
We did not have the time or bandwidth to do a sort of like full deep reading and evaluation and writing up technical comments in the way that we might have liked. So a few conversations and high level thoughts in 2024 is, or before is really all we were able to do. Yeah, a few conversations and high level thoughts in 2024 or prior to that is all that we could have done.
Is it fair to generally characterize your testimony as just background on how a state could do this, but not specifically commenting on how New Mexico is doing it?
Yes, that's exactly right.
Okay. And I'm just going to go through a few questions to explore that a little bit. So you testified generally to the contribution of transportation to aggregate PM and NOx. But you advise jurisdiction-specific assessments and modeling are typically required to quantify these benefits.
Yes.
Is that accurate? And you're making no comment or opinion on whether New Mexico has used specific assessments or modeling to quantify benefits?
Yeah, no specific comment. I reviewed the public document on modeling assumptions and parameters. At a high level, those all seemed reasonable to me. But I've not dug into any of the modeling with enough depth to have a terribly informed comment.
And you testified generally to the impact on retail gas prices in other jurisdictions, but you haven't done any analysis on the anticipated impact in New Mexico.
Yeah, I think you can make some sort of inferences by analogy. But no, I have not done anything specific, any quantification specific to New Mexico.
And would your inferences by analogy be that it would have a similar impact on fuel prices?
Yes, I think that
Oh, Mr. Noyes? You need a microphone.
Graham Noyes on behalf of the South Producer Group. Sorry, thank you. Graham Noyes on behalf of the SAF Producer Group. I believe the witness began by responding that he could perhaps respond by analogy. That does not sound like anything that's going to inform this proceeding.
Okay.
Madam Hearing Officer,
Ms. Olson.
Dr. Murphy here is being presented as an expert. It's common in legal proceedings for experts to give opinions in their expert testimony. Dr. Murphy did specifically say that he could draw some opinion based on analogy, and so I'm simply completing the testimony that he has offered.
Yeah, I'm sorry, Mr. Noyes.
Thank you. I don't believe he's been qualified as an expert witness on economic issues.
Okay, I believe we may not have gone through that exercise formally, but I believe he is offering expert economic testimony. Is that your understanding, Dr. Murphy?
yes, there was some discussion of it in my written testimony.
Right. So thank you, Mr. Noyes. I agree with you, Ms. Olson. Please go ahead. And let's see. Right. When you're finished with Dr. Murphy, we'll need a break.
Okay. Sorry, I just try to regain my train of thought there. So I think you were just testifying that it would be, you would see a similar increase to fuel prices. That would be your expectation.
Objection, Madam Hearing Officer. Slightly different than Mr. Noyes. We have established quite solidly that Dr. Murphy is not testifying about New Mexico. And I understand the analogy, but you also explained during your pre-hearing conference that you were not going to allow exploration of speculation.
Madam Hearing Officer, this is directly at issue in his testimony. He is testifying to the impact on retail gas prices, and he's testified that he can provide some information on the impact to New Mexico. He opened the door. I don't appreciate the continued disruption of the questioning.
Right. And I think actually I did hear him say yes before you objected and before Mr. Noyes came around the side of the room. To the extent, Dr. Murphy, it would be helpful for you to expand on that answer that you might expect a similar impact. Please do that now.
So in the other states that have adopted similar programs, the price impacts in early years are very small. For a number of years in most states, they're a few pennies, sometimes less than that. I think California wasn't until 2017 or 18 that they even eclipsed a nickel a gallon. Once you get into higher targets, there's the potential for some more impact, but we have seen in all the other states that they're smaller than seasonal gas price fluctuations. They're smaller than normal fluctuations you see from geopolitical impacts, and all the cost benefit analyses that have been done on similar programs in other states indicate the benefits far outweigh the costs, including as you transition to a more heavily electrified fleet, the actual aggregate cost of transportation goes down. And given that these programs are very helpful in supporting that transition to electrification, you get additional cost reductions from that transition as well.
Thank you. Go ahead, Ms. Olson.
Okay, I think maybe our answer got a little far afield of what we were discussing. The the retail gas price impacts. So if we could just back up to that specifically, can you just repeat your answer on the retail gas impacts? I'm hearing you say it would be similar to what we've seen in other jurisdictions.
I'm sorry. I think he just gave you a really thorough answer about retail gas prices.
I'll take your word for it. And you would agree that New Mexico's retail gas prices are not necessarily comparable to California's gas prices?
Objection, Madam Hearing Officer. I understand that Ms. Olson is attempting to characterize this witness as an expert on fuel prices. In these proceedings, we do not have the same rules of procedure or evidence when it comes to experts. Instead, we have technical testimony that's filed, and to the extent this exceeds the scope of Dr. Murphy's testimony, it's irrelevant, and we've established this.
Right.
I feel bad continuing to object, but
Madam
it's
Hearing
happening.
Officer, may I just briefly respond?
Yes.
Dr. Murphy's testimony includes testimony on retail gas pricing. If counsel is suggesting he is not an expert in retail gas pricing, then I move for that testimony to be struck.
Okay, so we've heard him now. This is at least twice. Talk about the trends early in a CTFP program, later in a CTFP program as the targets go down or go up. So he's addressed that now a second time, but Ms. Sona and I think Dr. Murphy have also been clear that he was not making a specific study of New Mexico specific factors. And so before you can even ask him about New Mexico gas retail prices, I think that is outside the scope.
Well, Madam Hearing Officer, the concern is that the board is taking his testimony on what's happening in other jurisdictions to be applied to New Mexico. And I think it's critical to be able to draw out distinctions. If Dr. Murphy doesn't know, he can say, I don't know. But I think it's unfair to have testimony in that we can't draw out the potential limitations of that testimony.
I think he and Ms. Sona have been clear about the limitation, which is he's speaking generally and not having made a specific study of New Mexico. Do I have that correct?
Yes, that's correct. Michael Ford from NMED has done more analysis on specific impacts to New Mexico. I think he's better positioned to talk about that. I can speak to the impacts of programs and programs like CTFP and long-term trends, but talking about the function of the petroleum industry writ large is a bit outside my purview.
Right, it's a scope issue. It's
understood. So your testimony is that your analysis of what's happened on other retail gas prices in other jurisdictions bears no relevance to what you would expect to see in New Mexico.
Objection.
That's a mischaracterization, Ms. Olson. Do you have other topics to explore with them? You've got
All right.
about 16 minutes.
I'll move on.
11 minutes.
So your testimony generally walks through contribution of various greenhouse gas sources that inform the California rule. Is that correct?
Yes.
And do you agree that the various greenhouse gas sources differs among the jurisdictions?
Yes, the greenhouse gas profile is going to be different from jurisdiction to jurisdiction. There are some common themes and threads. Transportation is a major source of greenhouse gases in every U.S. state that I'm aware of.
Have you analyzed the specific contribution of transportation in New Mexico?
I have not, but I believe some of the analysis done and that will be presented by other witnesses has.
So you're not making any comment or testimony to the contribution of transportation to greenhouse gas in New Mexico, correct?
I mean, it is a significant source of greenhouse gases. I think that is fairly obvious. Beyond that, in a quantitative way, no.
How do you define significant source?
I would say at least a quarter of the total greenhouse gas footprint of the state comes from transportation, and I include the production of fuels in that, not just tailpipe emissions.
Okay. And I think perhaps the last part of your testimony goes into some of the benefits of Clean Fuels Program. And one benefit you highlight is that credit revenue may be used to support transition to vehicle electrification. Is that accurate?
Yes.
In drawing those opinions, did you review New Mexico specific legislation?
No, I was looking at the decisions made by regulated parties and credit generators and other jurisdictions with similar programs. We've seen electric vehicles are a very rapidly growing share of credits in most other programs. Again, there's no requirement in the other programs that electric vehicles be the source of compliance credit. They happen to be, and they happen to be the lowest cost option available, so they've been growing there.
But you have not looked at New Mexico legislation regarding electrification of transportation?
I read it over. I am not an expert in New Mexico law, so some details and nuance may escape me, but I saw nothing in the legislation or the draft rule that makes me think there's going to be a very significant difference in the way the program treats electric vehicles here as compared to other states.
Okay, thank you. I have just a few questions for Mr. Vaughn.
All right, thank you.
Good afternoon, Mr. Vaughn.
Hello.
So I think your testimony does get into the contribution of greenhouse gas emissions in New Mexico based on the report, correct?
Very briefly at a high level.
And I believe your testimony is that the total contribution of transportation sector to greenhouse gas emissions is approximately 20%.
I believe that's correct. Yes.
And have you compared how that contribution relates to contribution of the transportation sector in California or Washington?
While I have reported on the high-level statistics of greenhouse gas emissions from the transportation sector in New Mexico, I am truly not the best person positioned to discuss the greenhouse gas emissions from the transportation sector here.
And who would that be?
I believe it would be either Mr. Matt Drews or John Kupal, probably.
Okay, thank you. And I believe your testimony on the development of the rule mentioned that to ground the CTFP in robust scientific data and industry expertise, New Mexico Environment Department conducted meetings with prominent research institutions and trade associations. Is that accurate characterization?
I believe so. If you could provide the page number, I could go there with you.
Let's see here. Apologies, I lost my. Let's see, page 26.
Could you restate the question, please?
Yeah, I'm just looking at that first sentence. To ground the CTFP in robust scientific data and industry expertise, you conducted meetings with prominent research institutions and trade associations.
That's correct.
And this was in drafting the initial rule. Is that accurate?
Yes, as I've testified earlier, my testimony covers the development of the rule from April 2024 through September 2nd of this year, which would be the petition rule.
Okay. And you go on to list some of these. You have the Michael Wang of GREET at Argonne National Lab. Is that is his expertise in development of these policies nationwide or specific New Mexico development of the specific New Mexico policy?
You're asking if we consulted his expertise on a national versus a state scale?
I am not familiar with Michael Wang, so I was wondering if his expertise is on a national scale or if he has New Mexico specific expertise.
Well, I couldn't possibly testify to the exact expertise of Mr. Michael Wang. What I have noted in my testimony is that he is one of the principal investigators of the GREET model at the Argonne National Laboratory.
I apologize. I started from the assumption that because this was in your testimony that you were involved with the engagement. Were you not involved in that?
Yes, I was at the meeting with Mr. Wang.
Okay, but you don't know what the area of his expertise is.
I feel like I've answered this question. He is one of the principal investigators of the GREET model, which makes him an expert in how the GREET model operates and its methods and assumptions that go into it.
Okay, but with specific respect with consulting him for drafting this rule, were you consulting him on his national experience or did he bring something specific for New Mexico?
Madam Hearing Officer, if I may, perhaps council can rephrase the manner of what she's trying to get at. I don't think this witness understands the question or it's outside the scope of his testimony because we've gone over it a couple times and he's not able to answer.
Okay.
Yeah.
I can move on.
Yeah,
it
please.
Sounds like he just doesn't know. And then it looks like the other folks that you highlight in that section are from New Mexico State University Cooperative Extension Service and UNM's Staff Council for Environmental Sustainability. Is there any other academic partners within the state that should be included in that list?
Whether or not an entity should be included in this list, I think, is irrelevant. These are some of the industry and research-based organizations that NMED specifically reached out to. If another industry or research-based organization reached out to us, then they were classified in my testimony as an interested party.
Okay, but this is an exhaustive list of the research institutes that you NMED reached out to, not you specifically, but the department in drafting this rule?
Sure, yes.
Yes. Okay.
We need a break soon, Ms.
sorry.
Olson.
Let's take a break.
Are you done with
Yes.
Mr. Vaughn?
Mhm.
You are. All right. Let's take 15 minutes, come back at 3, and we'll turn to Ms. Borchard and Dr. Russell. Who will you turn your attentions to next, Ms. Olson? What? Oh, wait till the microphone is turned back on. Okay. Ms. Olson?
Okay. All right. My next line of questioning is for the Bureau Chief, Miss Orchard. I'm gonna call you Miss Orchard. It's been a long day. Okay. So I'm gonna start with page 2 under your qualifications. And you indicate you've played a significant role in developing the revised proposed new rule. And just for clarification, does that have some context for the prior draft of the proposed rule?
You'd have to point me to my actual words, but no. I mean, I've been involved since the inception of the rule drafting.
Okay. So I'm assuming you were just commenting that you have played a significant role in developing the revised proposed rule, but it didn't mean to comment on earlier drafts of it. You were also involved in those.
Correct.
Okay. And then on page 3, you indicate that you manage the rulemaking team and that you made design decisions for Part 92. Is that also correct? I can give you a minute to get organized.
Okay, so I'm on page 3. Could you repeat the question?
Yeah, you indicate that you manage the rulemaking team and you made design decisions for Part 92.
Are you talking about the second full paragraph on page 3?
Yeah, just summarizing your qualifications. Is it accurate that you manage the rulemaking team?
Yeah, that's accurate.
And that you made the design decisions for Part 92. Is that also accurate?
Well, I'm not quite sure where you're getting that, but I mean, it's a team effort. We all met frequently, regularly. We all participated in as many meetings as we could. We all read as many documents as we possibly could, and parsed them out. Got back together, and collectively discussed. Met with Washington, met with California, consulted with experts, and collectively we developed this rule.
Okay, so as bureau chief, were you kind of the leader of that effort, or you were just another person involved?
Actually, Mr. Vaughn was the leader of the effort as the project manager. I would actually say, as far as making the day-to-day happen, and the kind of the managing of the rule as a project, that was more Mr. Vaughn's area of expertise.
Okay, I'm going to go through some questions, if they're directed to Mr. Vaughn, then I'm happy. If they're better directed to Mr. Vaughn, I'm happy for him to provide the answer, but I'll start with you. So throughout your testimony, you repeatedly referenced the implementing statute, and I'm assuming you're familiar with that.
Yes.
And that statute is provided as part of NMED Exhibit 3, if it's helpful for you to look at it for these questions.
Okay. Yes, I'm there with my exhibit.
Okay. So 74.118C2, the last requirement is to reduce the carbon intensity of transportation fuels in the state by at least 20% below 2018 levels by 2030 and at least 30% below 2018 carbon intensity levels by 2040. Does NMED interpret that to mean that the target is 20% by 2030 and 30% by 2040?
In this rule, we have interpreted as such. I think that depending on how what we see is happening in the credit generation and deficit generation in our program after a couple of years, I think that the statute, my interpretation of the statute is it allows us flexibility to change that based on what we see is happening with the program.
Would NMED initiate a new rulemaking to target a percentage other than 20% by 2030 and 30% by 2040?
Yes, we would.
Staying on section 74.118C2, the provision states that the CTFP rules must be applied to reduce the carbon intensity of transportation fuels in the state. Is that right?
Yes.
And section 74.13I defines transportation fuel to include electricity, correct?
1(3)(I). So now we're going to the definitions.
On the statute. Mm-hmm.
Duties, definitions. Duties. Definitions.
I can go back to my question if it's helpful.
No, I think transportation fuel, right? Does it include electricity? Yes. So the first thing on there, yes.
Okay. And then when we look at the Part 92, 20.2.92.101C1 establishes electricity as an opt-in transportation fuel, which is presumed to have a carbon intensity less than the CTFS. Is that correct?
Yes.
What is the statutory authority for permitting life cycle GHG reductions for electricity to be conditional or opt-in while the others are mandatory?
Objection, Madam Hearing Officer. Framing of the question calls for a legal conclusion.
All right, I'll just caution the witness not to offer legal conclusions, but to the extent you can answer the question as the chief of the Regulatory Bureau, please go ahead.
We looked to how other states do that, and also the fact that the utilities can elect to participate. And that was some of the things that guided us to make that decision.
Have you considered whether the department has been authorized by the legislature to make that determination?
We believe it yes, I believe it has.
Okay. And do you have what is the basis for that belief?
The fact that the utilities are opt-in and they're the ones who are going to be getting the electricity credits.
Okay. On page 87 of the CTFP regulation, table 4, the New Mexico statewide fuel pathway lookup table.
Yep.
And according to the table, the carbon intensity total lifetime emissions for electricity is 0.
You'd have to add the qualifier of renewable electricity to what you just said.
Okay. Looking at section 74.118C6, the subsection starts by requiring the department to consider similar programs in other jurisdictions. Is that correct?
C6. Yes.
And will you agree with me that that includes considering the legal status of programs in other jurisdictions?
Objection, Madam Hearing Officer. This calls for an interpretation of the law. Again, a legal conclusion.
All right.
Madam Hearing Officer, may I respond? I'm not asking her what is the legal status. I'm asking her, as the agency that's implementing the language of the statute, whether she would agree in that interpretation.
I understand. Same caution, Ms. Borchert.
Can you please restate the question?
Yeah, looking at 74.118C6, that statute requires the department to consider similar programs in other jurisdictions. Will you agree that includes considering the legal status of programs in other jurisdictions?
I wouldn't say that we ever considered the legal status of other programs, because in that sense, we were only looking at programs that were legal, i.e. established. When we were looking at other programs, we did often look at the language that established the program, and we also looked at the rules that were enacted as a result of the statutes in those programs. And we also consulted with the staff to find out how things are actually working on the ground.
And did you consider any provisions that were challenged or changed as a result of challenges?
We did not trace programs, statutes, or rules over time. So to some of the things that, for example, Dr. Murphy testified to, we were not really concerned with that. We were concerned with what's on the books now, statutes and rules, and how they're being implemented.
And then let's see, on page 4 in the bottom paragraph, it says the CTFP is oh, sorry, I'm back to your testimony. Oh no, I apologize. I think this is. Yeah, okay, page 4 of your testimony.
Okay, and there.
The CTFP is an essential and effective program to reach the climate pollution reductions in Executive Order 2019-003 in the transportation sector. Are you with me?
Yes.
That Executive Order 2019-003 has been provided as NMED Exhibit 7.
I'll have to take your word for it.
Based on your experience having worked in the government for many years, you recognize executive orders can be rescinded, correct?
Yes, I do.
And then moving on to page 5, top paragraph, you indicate the CTFP builds on other existing state initiatives, programs, and regulations. And let's see, I think you first list the New Mexico New Motor Vehicle Emission Standards, NMVES, that's adopted at 20.2.91 NMAC. And that's the clean cars regulations, is that right?
Clean cars, clean trucks, heavy duty omnibus regulations. New Mexico's version.
Okay, and then the next one you list is the Electricity Transmission Act.
Yes.
And what is that?
I'm sorry, but maybe you have a typo in here. I think it's the Energy Transition Act.
Okay,
Electricity
that
Energy
was
Transition Act.
my question.
Transition Act.
Referring to.
Oh, sorry. All right. It says Electricity Transmission Act. In reality, it's the Energy Transition Act.
Okay. And this can also be a source of confusion, but by referring to the Energy Transition Act, is that inclusive of the renewable portfolio standards that are codified under the Renewable Energy Act?
Yes, the RPS, the Renewable Portfolio Standard, is a component of the Energy Transition Act.
Okay. And then you also talk about transportation, electrification planning. Is that referred to the statute at 62.812, the Public Utility Act?
I know that 62 chapter of the state statute is about utilities. I'd have to go look that up if you're asking me which part in particular of the Utility Act is regarding electrification planning, but actually it might be in our rules. Do you want me to try to find that?
You can take my word for it on the citation. I just wanted to make sure that that was in reference to the statute applicable to the electric utilities for transportation electrification planning.
Yes.
And then the biodiesel mandate, can you describe what that is?
Yes, New Mexico has a biodiesel mandate that 5% of all the diesel sold in the state contain 5% biodiesel.
And finally, the agricultural biomass income tax credit.
Yeah, I'm not quite as familiar with this, but in general, this is an incentive, an income tax incentive that is geared towards the agricultural sector, that when they take their agricultural waste and convert it into reusable materials, they're eligible for this income tax credit.
So going back to the first sentence of that testimony, that the CTFP builds on these existing initiatives, has the department considered the greenhouse gas reductions that are anticipated from these other programs?
Yes, some of them.
And if you were to include the renewable portfolio standard mandate under the Renewable Energy Act, what are the projected emission reductions as compared to a 2018 baseline? If you include.
Objection, Madam Hearing Officer. I believe this is outside the scope of Ms. Borchardt's testimony.
And I think I started at the beginning by saying if it's better directed to a different witness, she's welcome to tell me who I can direct that to.
Ms. Borchardt, to do that.
Yeah, I'm partially confused by your question because while my bureau does do our greenhouse gas emissions, it doesn't come off of a 2018 baseline.
Okay, let me back up. So I think the projections for the rule are the deviation from the 2018 baseline. Is that correct?
The baseline on which the standards are based is a 2018 baseline.
Okay, and if you include the Renewable Energy Act portfolio standard mandate, how does that impact the projected reductions against the 2018 baseline?
We calculate the CI value based on the actual CI of utilities. And, it's a complicated question because the Energy Transition Act requires certain reductions in increments. If I remember, it's 2030, there might be a 2040 and a 2050. So there are no real reduction requirements except for in those incremental steps. So it's a different time scale than what the CTFP does, which is annual.
So when you're looking at the projected reductions attributed to the CTFP against the 2018 baseline, is that inclusive of the projected reductions that can be attributed to the Renewable Energy Act mandates? Or have you analyzed those separately?
The 2018 baseline predates the Energy Transition Act.
I'm not sure that's accurate, but if that's your understanding. So I guess maybe has the department evaluated the impact that can be attributed to renewable portfolio standards separately from the impact from the reductions that you're attributing to the CTFP program?
I am pretty sure that the first renewable portfolio standard increment is 2030. So none of the utilities are yet required to meet any RPS standards. So it would be hard to do that estimation since there is no specific, what we call a glide path in the industry, in our business, between the starting place and where they have to be in 2030.
Okay. That's all the questions I have on that topic. And then the last line of questioning I have is on fees. And so I'm going to direct these questions to you. But again, if one of your co-panelists is better equipped to answer it, I'm happy to have you defer those questions to them. Has NMED made any projections of the anticipated fees to be collected from registrations? Registrations.
I think we've put maybe what you call paper to napkin. Pencil to napkin. We do not know how many regulated parties we have in New Mexico. And that's in part because that's business proprietary information. And even though we had a lot of participation from fuel companies in the process leading up to this, not a single one of them actually volunteered any information that would help us get to this answer. So it's hard for us to project how much we're going to get from registration costs.
Okay. I believe there was testimony yesterday based on discussion of other states that most of staff time is spent on reconciling reports from deficit generators. Do you recall that testimony?
Yes.
Is there an estimate of what most of the staff time, can you quantify that as a percentage?
No, what I would say that Washington, that is a couple years into their program, has the same split, 95-5, based on, and that's also who we were in conversations with. So this is a great example of us looking to see how other programs doing it, and in conversation with them, thinking that this is reflective of reality.
And has the department estimated then the expected staff time to handle reporting from credit generators?
Well, I think that it's going to be a lot less.
And does the department have any estimate of how many credit generators there may be?
A lot less.
Is there any figures of total numbers of credit generators or deficit generators, or you're just doing it as based on what you've seen in other jurisdictions?
Madam Hearing Officer, this line of questioning about forecasting is outside the scope of Ms. Borchardt's testimony. It's sort of, I understand, related to fees, but this is outside the scope of her testimony.
All right. Ms. Borchardt, you agree with that? All right.
Yes.
Ms. Olson.
Madam, as the bureau chief, if she's not able to answer these questions, I think it's completely reasonable for her to identify who the person that they would be better directed to is.
Is there another department witness who will be talking about that?
No, there is nobody that could provide those answers.
All right. Ms. Olson, you have 3 minutes left with Ms. Borchardt.
Okay. I think that's all the questioning I have. Thank you.
All right. Thank you. Mr. Maxwell, I believe you're on the platform. Do you have questions of this panel?
Hello. My questions have been answered. Thank you.
Thank you very much. Mr. Harris or Mr. Boutier?
Madam Hearing Officer, if I may, if the parties have specific questions of Mr. Vaughn that'll relate to the 2 exhibits we need to provide him digitally, if you could let me know so I can make sure to get the computer charged back up to him and be prepared, that would be very helpful. Thank you.
Mr. Harris.
Thank you, Madam Hearing Officer. Can you hear me? Do I have feedback? Is everything okay? Thank you. Dr. Rasso, I'm going to start with questions for you. You've been identified as the NMED witness who can testify as to NMED's readiness to administer the CTFP. Is that correct?
That's correct.
And in your written testimony, you testified that, quote, that NMED, quote, has deliberately scoped the CTFP's rule to enable phased implementation, prioritizing the most critical components and allowing for the shortest possible delays in components of the rule as phase 1, and addressing the more difficult to administer CTFP components
such as alternative fuel pathway applications, project credits, and dyed off-road diesel reporting requirements in subsequent phases. Did I read that correctly?
That sounds correct to me.
Thank you. That was at page 2 and 3 of your testimony if you needed to refer. So as I understand your testimony, there's going to be a phase 1 of the rule and then subsequent phases of the rule. Is that correct?
I think I was referring to parts that are within the proposed rule that have different timelines than the effective date.
Okay. Well, then let's start with phase 1 then. What exactly are the more critical components of the rule that is phase 1 of NMED's implementation of the rule?
The first steps in implementation of the rule would be registration and the commencement of quarterly reporting of fuels.
I'm sorry, I didn't get that last part.
The commencement of quarterly reporting of fuels.
So those 2 components are phase 1 of the rule.
That is the first portions of the rule that will go into effect.
Okay. Is that the entirety of phase 1 of the rule?
I'm not. Let me review what I said real quick.
Take your time.
I suppose that would be phase 1.
Okay. And again, those components are currently part of the proposed rule, correct?
Yes, registration and quarterly fuel reporting requirements are part of the proposed rule, as are the other components that I list as being more difficult to administer.
And those are the subsequent phases of the rule. And you've listed again alternative fuel pathway applications, project credits, and dyed off-road diesel reporting requirements. Is that correct?
That is what I have listed in my testimony, yes.
Is there any other component of the rule that is part of the subsequent phases of the rule?
There may be.
I've noticed that a part of the rule is pointed out to you. Do you need to review the rule at all, or I just want to make sure I'm getting.
I'm sorry. Are you asking me to enumerate every component of this rule in order to break them into phases?
Well, I am looking to understand exactly how the rule is going to be administered. I understand you are the person who is the expert in administering and in explaining how the rule will be administered. Is that correct?
I have been focusing on planning for the implementation of the rule. That is correct.
Okay. And again, there's a phase 1 of the rule that has 2 components to it. Is that correct?
I think perhaps my wording of this as phase 1 and additional phases has you too focused. Throughout the rule, various portions of it specify the timelines and dates at which we will be accepting applications for portions, or in the case of dyed off-road diesel, when the exemption from the rule expires.
Yeah, okay. So I just want to make sure that I understand your testimony. So are you saying that you're amending your previous testimony as to what is involved with phase 1 of the rule?
I'm saying that perhaps you're taking my turn of phrase more literally than it was intended.
So is phase 1, and I'm really not trying to argue, but I see the term phase 1 in your testimony, and I'm just trying to nail down exactly what phase 1 is that will be administered first in phase 1.
Madam Hearing Officer, if council could ask perhaps broader questions. The witness has already said multiple times that her testimony phrasing isn't the accurate characterization for her to answer the questions that she, as she understands them.
Yeah, so I heard you asking originally about phase 1. then you reframe that question to ask about first steps, which she definitely understood, which was the registration and commencement of quarterly reporting of fuels. And I think to go back to the phasing framing, I think she has said now that that's not what the most helpful way to think about the manner in which the rule will be rolled out or implemented.
And I apologize. I didn't understand that to be how she answered. It may have been, and I just misunderstood it. I understood that the two components that she described were phase one, not first steps.
Okay.
But I could be wrong. I just want to know what phase one. I want to know what are the components of the rule of the shortest possible delays in components of the rule as phase one. I just want to know what those components are. That's it. And if you've answered, then
I believe I have answered that the first portions of the rule to come into effect are registration requirements and quarterly reporting.
I appreciate that. And are you saying that everything else are subsequent phases?
Again, I don't necessarily believe that the framing of this as distinct phases is the most helpful when in the rule itself, it is clear what dates different components take effect.
Okay, I appreciate that. I'm only using the word phases because that's the word that you used in your written testimony. Can NMED implement the phase one components of the CTFP today?
We are still in active development of the fuel supply equipment reporting module and the quarterly fuel reporting module of the data management system.
Does that mean no? That let me just ask a question. Does that mean that NMED cannot implement the phase one components of the CTFP today?
Objection, Madam Hearing Officer. The question's irrelevant because there's not a rule to implement. So today it is irrelevant.
The question actually goes to Director Miano's testimony yesterday. She was quite adamant that it could be implemented today, and that's all I'm asking.
Okay, so I don't know that it's that helpful. I think she's given you an answer. They're still developing two modules. And of course, today is not being proposed as an effective date of the rule.
Thank you, Hearing Officer. Can NMED implement the phase one components of the CTFP by the effective date of the rule?
Yes.
How do you know?
We are on track with our IT development contractor to have those modules ready in advance of the effective date.
Does NMED have the staff available to implement the phase one CTFP by the effective date?
We will, yes.
How many staffers will be needed to implement the CTFP by the effective date? Phase one of the CTFP by the effective date?
I believe Director Miano referenced our Bureau staff of 14 when answering a similar question. And I'd like to elaborate a little bit further on what she said. We are expanding my section of the Bureau to enable effective implementation of the rule. That includes our hiring of a life cycle analysis expert who started a week and a half ago, I think. And I'm also actively hiring reporting staff.
So there's one person who has been hired to implement the program?
That's in addition to existing Bureau staff.
And who are the existing Bureau staff that will be implementing the program? Administering the program, I apologize, it's the term you used.
So I will be administering the program. In addition to that, our existing staff include our economist who will be testifying later, Mr. Vaughn, who is our rulemaking and strategic initiatives specialist. We also have several other staff that focus on other projects who, if necessary, could be pulled from those existing projects to contribute to administering the program.
How many week hours are anticipated being needed per staffer to administer the program? Phase one of the program.
So phase one of the program, I think you're also talking about the initial registration period, which I anticipate being the heaviest load as far as registrations go, as we get the providers of regulated fuels registered into the program. I haven't done exact calculations on the number of staff hours, but I have also reached out to a temp agency because I anticipate that we will need additional staffing for that time period.
So when phase one is when the rule is implemented, administration of phase one will be through New Mexico Environment Department staff members and through temp agency personnel?
We also have additional contractors who we may call in if workloads begin to spike.
So that's two questions though. So there's going to be temp agency people and contractors?
We will have NMED staff.
Yes.
Supplemental staffing from a temporary agency, and
yes.
Typically we treat those as NMED staff in many ways, and potentially contractors.
Okay. And you don't know how many people you'll need at this stage to be able to administer phase one of the rule?
Objection. Asked and answered.
I'm sorry, I didn't hear it. Go ahead, Dr. Russo.
I haven't done a formal analysis. I am currently hiring 3 staff that will be 3 full-time NMED staff that will be focused on reporting and administration of the data management system. In addition to that, I think I will probably need 2 temporary staff for that 45-day period that providers of regulated fuels have to register in the program.
Thank you. How much money will it cost NMED to implement phase one of the program?
I think that might be better directed to another witness.
Do you know which witness?
Ms. Borchert, perhaps?
Thank you. Ms. Borchert, do you know the answer to that question? Would you like me to ask the question again? Doctor, no, I apologize. Ms. Borchert.
Are we going in order here, or is it okay for me to cross over when in this kind of a sequence?
Let's see. Mr. Harris hasn't questioned you yet. I make a note of how long your time is running, though. Go ahead.
Okay. Do I have a cost estimate? Ballparks, we know what we pay an average employee, somewhere between 6 and 8 employees. We know how much it's going to cost us approximately to continue the contract with our IT contractor who's working on the data management system. We also know, we have certain predictable expenses like the fuel forecasting report, and also continued analysis of the program, so consulting assistance, and then there's a kind of a set amount that every staff would need just for their operational needs, for their computers, their phones, their software. So I have a good sense of what more or less that'll be. I haven't actually penciled it out, but it's a reasonable amount.
Let me just a follow-up question. My actual question was, do you know how much money it will cost? And I guess maybe you said that yes, you do, but you didn't answer how much. Do you know how much it's going to cost? And if so, how much will it cost?
Well, I'm not going to give a number to you right here. So I guess if you want to know, do I know how much it's going to cost at this very moment? No.
Thank you. Ms. Rasso, I'm going to ask you questions about the subsequent phases of administering the CTFP rule, which are going to sound kind of familiar. Can NMED implement the subsequent phases components of the CTFP rule by the effective date of the rule?
The subsequent phases, we're talking about alternative fuel pathway applications, project credits, dyed off-road diesel reporting, and other components of the rule, we're prepared to administer by the dates identified in NMED's proposal.
Those are the dates those are the components that you've just listed. Is that correct?
Including the components I've just listed.
Okay. I just want to make sure. Will that cover the entirety of the rest of the rule? Not the phase one components, but everything else that needs to be complied with and administered as far as the rule is concerned. Have you just said that, can NMED administer the entirety of the rest of the rule by the effective date of the rule?
We are planning to administer the rest of the rule by the dates identified in the proposed rule, not the effective date. So therefore, I'd have to say no.
Thank you. And maybe this is answered in the question that you just answered, but I'll ask them anyway. Does NMED have the staff available? Will NMED have the staff available to implement the subsequent phases of the CTFP by the effective date of the rule?
We're planning to be prepared to administer by the dates that NMED has identified in our proposed rule, not the effective date.
Okay. And do you know how many staffers will be needed to implement the subsequent phases of the CTFP rule by the effective date?
I think the answer to that is probably in the range of 6 to 8 FTEs.
Do you have those staffers on staff currently, or will you need to get more staffers by that time?
That will require additional hiring.
I'm going to ask you some questions with regard to fuel pathways. If you're the right person to be asking those questions to.
I would be the right witness to talk about the types of fuel pathways and processes on applying for alternative fuel pathways. And processes on applying for alternative fuel pathways.
Currently, there's a table 5 to the proposed new rules that has predetermined values for fuel pathways. Is that correct?
Table 5 would be the temporary fuel pathways. Yes.
Okay, thank you. And you actually asked a question, or you made a distinction that I have a question about. Temporary fuel pathways. Why not allow a clean fuel producer to permanently use the values in Table 5?
One of the program in order to evaluate program performance, we need to be able to accurately characterize and evaluate the carbon intensity of transportation fuels delivered to the state. And many of these alternative fuels can have a wide range of carbon intensities. For accurate characterization, we prefer that fuel providers come in for alternative fuel pathways that accurately characterize their exact fuel life cycle carbon intensity.
Has the department allocated resources for the review of alternative fuel pathway applications?
Yes, we have hired other states call them fuel pathway specialists. His title is fuel life cycle analysis specialist. In addition, we have procured expert contracting services to assist in reviewing pathway applications.
And those were some of the temps or contractors that you were discussing earlier?
That would be contractors. And the fuel life cycle analysis specialist is an NMED staff.
What's the department's estimated timeline for the approval of alternative fuel pathway applications?
Oh, I think that's a very complex question that's going to end up depending a lot on the complexity of the application. I think it could be anywhere from, for a very simple application, a month, to it could take quite a long time. It could take 18 months for a complicated pathway where there's a lot of back and forth between the department and the applicant. And I should also add that we anticipate there being a large number of applications when we first open the fuel pathway application process on July 1st of 2026. So I'd anticipate those times being further delayed by the number of applicants during that period.
I'm going to ask you some questions about project-based crediting, if you're the correct person.
I think that might depend on the question.
Okay. Let me ask. If NMED has not considered the specifics of project-based crediting yet, how long can participants expect to wait to hear back on those applications?
I haven't considered the review time for project-based credit applications.
Has any,
I'm so sorry. The department, I haven't considered the review time for project credit applications.
has anybody at NMED considered the review time?
Not that I'm aware of. I would also add that as I sit here considering it, that one, I would also caution that it is likely dependent on the complexity of the application. There are potential for very simple project credit applications. For instance, using solar power rather than field gas to power compressors in the oil and gas fields would seem to me to be a simple evaluation.
Thank you. I have some questions for Ms. Borchert. Ms. Borchert, I think it's on page 22 of your testimony. You highlight how New Mexico is the only CTFP program to have a technology neutral requirement set in statute, correct?
Yes.
Did the department consider creating a definition for technology neutral during the creation of the proposed draft rule?
I'd also like to just preface that with the idea that technology neutral is the term used in the statute. Washington and I believe other states have neutrality requirements. So just because we're the only ones that have technology neutral does not mean that other states don't have neutrality or other, you could say, tech neutral adjacent type language in their enabling authority.
Okay, thank you. Would you like me to ask the question again?
Yes, please.
Did the department consider creating a definition for technology neutral during the creation of the proposed draft rule?
Perhaps. I don't remember. I also think that, the fact that it's used here twice and in two very different ways didn't seem to mean that a definition would necessarily capture the different ways in which it's used, and also the different ways that, so I think we considered it, but we didn't.
Okay. On page 6 of your testimony,
Okay, I'm there.
you define, from the definition itself, you define transportation fuel as, quote, electricity or a liquid, gaseous, or blended fuel, including gasoline, diesel, liquefied petroleum gas, natural gas, and hydrogen, sold, supplied, used, or offered for sale to power vehicles or equipment for the purposes of transportation. Is that correct?
That's straight out of the statute. Yes.
Straight out of the statute or straight out of the rule?
Statute.
Thank you. Since this definition explicitly includes electricity, why was electricity designated as a, quote, opt-in fuel rather than automatically included in the program like other transportation fuels?
Because of, as I mentioned, I was asked this question before, and the reason is because of the other provision of the statute that allowed the utilities to be opt-in, and so that suggested to us that if the utilities are opt-in, then electricity is opt-in as well.
How do opt-in fuels meet the technology neutral requirement of the statute?
Objection, Madam Hearing Officer. Well, never mind. I withdraw that. Sorry.
Well, the technology neutral quote from the statute is about establishing a tech neutral standard, and also in a technology neutral way, being able to determine the CI value. And that's how we are using tech neutral when it comes to electricity and to all clean fuels, right? A standard, and each standard gets compared against that standard, is a technology neutral way to treat all the transportation fuels.
Ms. Borchert, I'm sorry to interrupt. Would you pull the mic a little
Yes,
closer?
happy to.
And when you say all fuels, you're including opt-in fuels?
Yes. All fuels use the same baseline and have the same methodology of calculating the CI, the carbon intensity. So it's technology neutral in its approach to all fuels. Just so happens that some fuels are so far below the standard that it doesn't make sense to require them to report, because it's an opportunity for them to participate in the program, not a requirement.
How do the different fees for deficit generators versus credit generators meet the technology neutral standard?
Well, I think that technology neutral implies something about equitability, right? And so it seems perfectly equitable to charge users of administrative time equitably.
Okay. How does the difference in fees between a tier 1 fuel and a tier 2 fuel meet the technology neutral standard?
Objection, Madam Hearing Officer. The characterization of these questions is at odds with what Council just exhaustively went through to highlight in the statute where it states tech neutral identified with a standard.
Hey, Mr. Harris?
I'm unsure how a question asking how the treatment of two tiers differently is somehow consistent with a technology neutral standard? I'm unsure how that question is inappropriate for this witness.
Right. So you've asked a series of questions about how the tech neutral concept plays out through these. I hadn't heard the tier 1, tier 2. I remember the testimony earlier distinguishing tier 1, which was the kind of well understood. Was it Dr. Murphy? The well understood sort of fuels, and then tier 2 was more innovative. Is that a question though for you, Ms. Borchert?
Yeah, I'll answer it.
Would you like me to ask the question again?
No, I know the question was. By their design, they're tech neutral because we are not distinguishing any kind of fuel type coming in for a tier 1, a simplified pathway application based on some of the conditions that the hearing officer just laid out too, which includes the fact that it may already have a CI value in a different state. We already have an alternative fuel pathway in a different program. There's nothing technology neutral. There's nothing technology biased in sorting between easier fuel pathways and harder fuel pathways.
Okay, I've got some questions regarding banking credits. If you could turn to page 23 of your testimony.
Okay.
Does the CTFP program require that a certain percentage of the credit market be subject to potential forced pledging to the credit clearance market in section 507I?
The credit clearance market does require pledging, and it's important to consider with the rules, it says pledging does not equal selling.
Okay. Does this pledging square with touting the ability to bank credits for future compliance as a program strength?
Could you say the question again?
Sure. Does this pledging that you've just distinguished square with, I'll say touting off. Does this pledging does this pledging square with the touting of the ability to bank credits for future compliance as a program strength?
Yes.
And how is that?
The credit clearance market is only triggered under certain events, and even then, the compelled participation is only for credits for certain credit holders, those that hold credits that are longer than 5 years old, or that have more than 10% of the total banked credits. So if anything, I would characterize the trigger for pledging as almost an hoarding mechanism in the rule, although as I said earlier, it does not require that you sell them. And so to me, they're actually super complementary, not at odds at all.
I have another technology neutral question I forgot to ask, so I'm going to ask it now. Would the department consider creating a definition for technology neutral that would be applied in a standard manner across the entire program?
Objection, Madam Hearing Officer. These types of questions we've established are speculation, given we have not advanced to the rebuttal phase of the hearing yet.
Right. So, Ms. Borchert, you understand I'm definitely not going to ask you for a commitment to do one thing or another in rebuttal. If you would like to answer the question and have an answer, go ahead. Otherwise, you can reserve for rebuttal.
I would say that the statute has already given two technology neutral uses, And that seems to be the guiding principle around technology neutral. The legislature has spoken.
Thank you. Could you turn to page 21 of your testimony?
I'm there.
On the top of page 21, you state that NMED, quote, anticipates bringing periodic revisions of Part 92 to the board for consideration as the program's needs mature, the fuel credit market develops, and conditions change, end quote. Did I read that correctly?
Yes.
Were you here for Director Miano's testimony?
Yes.
Okay. Did you hear Director Miano testify that she hoped that the first needed rulemaking, additional rulemaking, might be as soon as 1 year from now?
I don't think that's a fair characterization of what Director Miano said. I think she said it could be as early as 1 year.
Okay. Does the department anticipate that there will be such greatly substantial maturation, development, or change in condition that in a year there will already need to be another rulemaking?
I hesitate to speculate on that. From a strictly bandwidth perspective, I sure hope not.
I imagine the board does as well. Why can't those anticipated needs be included as part of the process we're currently undertaking?
I'm sorry, could you repeat the question?
Sure. If there is an anticipated need for revision regarding maturation, development, and change in conditions, is there a reason that those aspects can't be included as part of the process that we're currently undertaking?
Absolutely. We really look forward to, they cannot be included in our rulemaking right now because there's a lot we're going to learn by implementing the program in the first quarter, in the second quarter, in the first compliance year. That's when the market gets established and we understand what kind of fuels are flowing into New Mexico as a result of this program. So there's so much we don't know right now that those are the kinds of things that will change. And that's when we need to be able to assess and decide what are tweaks, if necessary, as a result of what we know a year or two from now that we don't know now.
Thank you. Couple of questions, and I apologize. How much more time do I have with this witness?
With Ms. Borchert, let's see, it's 4:08. You get till 4:21.
I'll get it done. I've got some questions regarding the book and claim definition. I'm going to read the definition from the rule, and you can tell me if it sounds right. The proposed rule. Book and claim means the accounting methodology where the environmental attributes of an energy source are detached from the physical molecules or electrons when they are commingled into a common transportation and distribution system for that form of energy. The detached attributes are then assigned by the owner to the same form and amount of energy when it is used. And then I'm reading from the petition form of the rule. The last sentence under that definition is, for the purposes of 20.2.92 NMAC, the common transportation and distribution system shall be connected to New Mexico. Does that sound correct?
Well, you're reading from the petition draft.
Correct.
The revised draft has that last sentence struck.
Correct. But did I read the
yes, you did.
Draft correctly?
Yes.
Okay, thank you. In that definition, what is the meaning of common transportation and distribution system?
We mean that to understand whether, even though a particular physical molecule or electron may not get from point A to point B, that individual component, the distribution system is interconnected in a way that putting something in on one side and taking it out in the other is allowed by the network.
Thank you. Does a distribution system for liquid fuel include rail?
Distribution system, I would not think that it does.
Does it include trucking?
I would not think that it does.
And as you noted, the latest red line removed the connectivity to New Mexico language. What's the effect of that change?
The effect is zero because that sentence was removed because it occurs in the actual places within the rule where book and claim is used. So that provision still exists. It just didn't need to be in the definition.
Can you explain how book and claim would work in New Mexico for a product such as renewable diesel or ethanol?
Ethanol, I believe, has so it feels like we're talking about apples and oranges here. Ethanol, as
if you want, I apologize for cutting into you. If you want me to split up the question up, I can.
I will split it up.
Okay.
Ethanol, as I understand it, is trucked into the state. So there is no way for somebody to produce ethanol at the plant where they might produce it and then claim in New Mexico that the environmental attributes of that ethanol produced over Texas, I know in the panhandle of Texas, they want to produce ethanol, and then say, oh, we're just going to transfer the environmental attributes to ethanol that shows up by truck in New Mexico, right? A different ethanol. Has to be the same ethanol, has to be able to show that the environmental attributes that were assigned to the production of it actually has a pathway to get here that does not include a way for that physical molecule to get in here. For renewable diesel, I would say that yes, it is possible since we have lots of diesel pipelines, not lots, some diesel pipelines that enter our state where somebody could be somewhere producing renewable diesel, put it into the pipeline as a drop-in fuel. It could be put into the pipeline. On the other side, you could take out renewable diesel and say that indeed it was destined for New Mexico and consumed in New Mexico. Then in that case, they are in a connected distribution system.
And does that cover both ethanol and diesel? That answer then?
I thought I just gave you two answers for ethanol. No, so for ethanol, it does not apply. For renewable diesel, that was your question. Renewable diesel, it does apply.
Okay, thank you. Will NMED be providing more clarification on book and claim outside of this rule language?
It feels like we've had a lot of discussions around clarification, and if there's anything that that would be a good takeaway from Mr. Vaughn's testimony, it's the fact that our team is always open for conversations and discussions. So if somebody has a question about book and claim, they should absolutely feel invited to call us, and we will talk through book and claim with them.
Mr. Harris?
Yes.
The interpreters are having a hard time hearing you.
I'm sorry.
So you need to go closer to the mic.
How is this? Is this better? Yes, no?
Yes.
Okay, I'll scream. Sorry. How's this? I just hate that. I feel like I'm trying to be a rock star if I do this. It seems a little silly.
Be a rock star.
That's right. How is this? Is this better? Okay, I'll do that. And I apologize. Mr. Vaughn, I'll ask you a few questions. In your testimony yesterday, you indicated that you met extensively with California and Washington regulators to try to learn what has worked and what has not worked in their programs. Is that correct?
That is correct.
I think you said you met with Washington ecology staff on, my number is here, on at least 43 occasions. Is that correct?
I know this is documented in Appendix A of my written testimony. I believe the 43 meetings that we had with the Washington Department of Ecology were mostly focused on the design and implementation of these types of programs. I also believe that there, excuse me, were approximately another 20 meetings with the Department of Ecology focused on working through the development of the data management system.
Thank you. So dozens of times you met with, for example, Washington regulators, and they gave you their insight on what worked and didn't work with regard to its program. Is that correct?
Yes.
Thank you. Can you expand on what they told you were the lessons learned in their programs, particularly areas in which they encountered challenges or problems that required course corrections?
I apologize. Nothing immediately comes to mind. I mean, as I did state in my testimony, though, in my oral testimony yesterday, I mean, truly, we left no stone unturned. We've probably discussed every single mechanism in this rule with the Department of Ecology, whether it be deferral, the credit clearance market, whether it be reporting, any of the mechanisms in the rule. I am sure that we have discussed them with the Department of Ecology, and broadly, yes, they have trained us on what has worked in their state and their program, and helped to guide us.
Did they? So they told you what worked. Did they tell you what would not work?
Probably. I'm sure that they had a couple of recommendations to that effect.
Did NMED keep a list of things that didn't work?
Whether or not we kept a formal list, I'm not so sure. We certainly, recorded notes of our conversations with the Department of Ecology.
Okay. Do you remember, just here, offhand, do you remember any specific things that you were advised to steer clear of or problems to try to avoid?
I don't recall any specifics at the moment. Many of my colleagues were involved in those meetings. They may have a better recollection than I do at the moment.
Okay. If NMED, and maybe perhaps you in particular, met with Washington regulators so extensively and followed their example so closely, why did NMED not include an initial extended credit requirement or retirement? Excuse me, I'm going to ask this question. If NMED met with Washington regulators so extensively and has followed their example so closely, why did NMED not include an initial extended credit retirement period similar to Washington's?
Are you referring to the essentially the first compliance period in Washington that's sort of spanned more than a calendar year?
Do you understand there to be an initial extended credit retirement period in the Washington program? To have been one?
Objection, Madam Hearing Officer. These questions, when they were related to discussions with Washington staff as part of engagement, these specific nuances of this, I think they're outside the scope of Mr. Vaughn's testimony.
And if there's somebody else who will be able to answer why there is not such an extended retirement period as has been followed by Washington, that's fine. I'll ask that person.
Okay.
Well,
Ms. Sona, right. So I think it is outside the scope of Mr. Vaughn's testimony. Mr. Vaughn, is there another witness who would be better to answer that?
There may be on this panel, but I couldn't necessarily speak up and identify them, but if they were willing to identify themselves.
Okay. Thank you. Oh, sounds like Dr. Murphy just bid on the auction item right there.
I was even going to let you off the hook. And so go ahead.
I would say my recollection is in Washington, there were some IT challenges in getting their system spun up in the first year, which contributed to that. I think also just it was a strategic decision. There are, again, as I mentioned in my testimony, there's not a lot, but there's a fair amount of flexibility to make decisions to reflect the local conditions. I think those two things probably explain at least part of the rationale.
Part of the rationale?
Yes, I certainly can't speak for the Washington regulators in any more depth than that.
Thank you. Mr. Vaughn, do you have anything to add to that?
The only thing that I would add is that I believe that the deferral mechanism part of the rule.
Did you testify that delayed implementation of the program would not be possible because the program has less than 5 years to reach its goal?
I believe so. And part of what I meant by that is that the longer we delay the implementation of the rule, the fewer greenhouse gases emissions that would be reduced from the program overall. And I believe that is not consistent with the intent of the statute.
Couldn't the current year 1 reduction be added to year 2?
I believe that's outside the scope of my testimony.
Okay. Do you know who might be able to answer a question like that? Oh,
Ms. Borchert.
Ms. Borchert.
I think you're confusing the CI standard with greenhouse gas emission reductions. And so every year of delay means no greenhouse gas reductions occur in that year. The CI curve can be steeper, but really it's the area under the curve that represents greenhouse gas reductions. And when you lop off a year of the curve, you lop off greenhouse gas emissions.
Thank you, panel members. I really appreciate your time and patience. Thank you, Madam Hearing Officer, and thank you, board members.
Thank you, Mr. Harris. Mr. DeSalen, do you have questions for the department panel?
Thank you, Madam Hearing Officer. I lost my microphone. Sarah Gerson, who is on the platform, will be questioning the Environment Department witnesses. Thank you.
Thank you very much. Ms. Gerson, can you unmute yourself?
Yes, thank you. Hopefully you can hear me now. My name is Sarah
No,
Gerson.
I'm sorry, Ms. Gerson, you're too soft.
I will try to speak more loudly. If I cannot resolve the problem, I can get a headset from the other room. So please let me know if that's necessary.
Yes. Our court reporter really cannot hear you.
Okay, I apologize for this delay. I'll be back.
Okay.
Hi, good afternoon. Is this more appropriate?
Oops, that was a very short stretch break. Come on back. Ms. Gerson, would you speak, please?
Hi. Does this resolve the issues?
That is definitely not better. It might be worse.
I can switch to a different computer. I am so sorry.
All right. I might ask another person if they have questions too, until you figure that out. But go ahead, try to figure that out.
Thank you, hearing officer. I appreciate it.
Let's see. For Food and Water Watch, will Mr. Lodell or Ms. Rayno have questions?
Madam Hearing Officer, people are pointing out online that Ms. Gerson seems to be coming across loud and clear, so it might be an issue with our speakers in the room.
Louise? No? Oh, that's right. Okay. Should I make the joke about turning it to 11? Okay. Let's see. She's not here though, is she? Okay. So I'm not too loud, right? Coming from there? We just don't know about someone online. Member Bitzer, would you speak up so we can just check the sound?
Testing, 1, 2, 3.
That's great. Thank you so much.
She was coming across fine out here in online land.
Okay. Oh, and I see Member Hunker. All right, when she comes back, let's see. Were Mr. Lodell or Ms. Rayno here to say whether they had questions of the department panel? No? Okay. Mr. Soreas, are you on the platform and are you going to have questions of the department panel?
Hello, Madam Hearing Officer. Yes, we do have questions for the panel.
Okay. Then I think I'll be calling on you tomorrow at this point. Let's see if we can get Ms. Gerson back. Thank you for confirming.
Thank you.
Okay, Ms. Gerson, would you speak up now? Getting situated. Ms. Gerson, you're unmuted. And you can unmute yourself.
Madam Hearing Officer.
Ms. Sona.
May I address a brief matter while Ms. Gerson?
Yes.
I just wanted to share a concern and an encouragement, given the amount of time we took to move through just a few parties for this panel, that a significant amount of questioning was directed to potentially the wrong witness. And so, there was back and forth a lot about finding the right witness. I would just encourage for tomorrow and for the next panel, trying to do homework as best as possible in reviewing the testimony to try and get that witness right. NMED did try to be quite clear about who is talking about what in their testimony.
All right, thank you. I have to refresh my memory every time too, actually. All right, Ms. Gerson? Can you hear me? Would you speak?
Is my line unmuted? Can you hear me?
Yes, that's terrific. Thank you. Just keep your voice up, please. I'll start your time.
Good afternoon, hearing officer, chair, board members. I just want to state again my deep appreciation for you bearing with me on my technical challenges. And I will dive right in with some questions for Dr. Murphy. I guess I should also introduce myself. My name is Sarah Gerson. I am here representing Coalition for Clean, Affordable Energy. Dr. Murphy, would you please turn to page 5 of your written testimony and let me know when you're there?
All right, I'm there.
On this page, you highlight a few general benefits of clean fuel programs as a decarbonization tool, correct?
Yes.
And in the very last sentence on this page, you state that, quote, all revenue other than program fees stays within the transportation system.
Ms. Gerson, you're going to have to really speak up.
Okay. Dr. Murphy, is it correct that you testify that all revenue other than program fees stays within the transportation system?
Yes.
Can you explain for the board why it's relevant to know that most of the revenue in a clean fuel program stays within the transportation system?
It's because this means there's no net sort of cost added to the transportation system from the program. You have some fuels get more expensive, some fuels get cheaper by an equivalent amount, but the aggregate spend on fuels remains generally the same.
Okay, thank you, Dr. Murphy. My next question deals with your testimony on page 16 of your written testimony. So please let me know when you're there.
I'm there.
Here you're discussing the air quality benefits of clean fuel standards, correct?
Ms. Gerson, your voice keeps dropping. I'm sorry, we need you to almost shout in order to hear you in the hearing room.
I apologize. I will do my best. Dr. Murphy, in the last paragraph on this page, you discuss a study that modeled the expected air quality benefits of expanding Oregon's clean fuels program, correct?
Yes.
And in the very last sentence, you explain that the scope of this analysis included multiple clean transportation policies, including what you refer to as EV requirements, correct?
Yes.
And And when you say EV, that stands for electric vehicle, correct?
Yes.
And I also want to clarify what you mean by EV requirements in the sentence. So, can you tell me what requirements you're referring to?
At the time of that study, Oregon had. Sorry, they handed me a headset that I'm worried is going to get feedback. At the time of that study, Oregon had adopted California's Advanced Clean Cars 2 rule, and I believe also the Advanced Clean Trucks rule. So those were also helping shift the total emissions profile of the state. You can't really isolate one policy from another when multiple policies are going to be in effect at one time. The value. So things like the Clean Fuels program in Oregon help make help speed the deployment of vehicles and help make it possible for states to achieve targets like those that would be set under Advanced Clean Cars 2 or similar rule. So it's really impossible to completely disentangle one from another. We can say with very high confidence that without that full portfolio, the total emissions benefits would not have been equivalent to that. Like if we tried to look at an Advanced Clean Cars tool without everything else, I'm confident we wouldn't have seen that. Certainly, the costs would have been very different as well.
Madam Hearing Officer,
Ms. Sona.
I personally am having a very difficult time as well hearing Ms. Gerson. I'm wondering, given that it's 4:40, if it's, if this is an issue where we may be able to resolve this in the morning at 8 a.m., where she can get the audio worked out and continue her questioning. If another party has a very short line of questioning that we could accomplish in the next 20 minutes, if perhaps the parties would be open to switching the order a little bit. It's just very hard to participate with this.
Okay. Ms. Gerson, I'm sorry, it has been a real challenge to hear you in all three settings here. And I'm wondering, will you be able to join us in the morning?
I will certainly endeavor to do that, and I will defer to your discretion on how you best want to use the next 20 minutes of today.
Yeah, I'm concerned that many of us are so challenged to hear you, and we did turn up the speaker in the room, but it really is a challenge. Let me ask Mr. Sarayas, would you have a constructive 20 minutes for one or more of the department panelists?
Madam Hearing Officer, I believe we'd need a bit more. We'd need more time than 20 minutes, and our preference would be to stick with the original cross-examination order.
Okay, Mr. DeSalen, I'm sorry, I didn't hear you. Please speak into a microphone.
Thanks. I thought you were addressing me, Madam Hearing Officer. I'm sorry. My apologies.
Okay.
And I just tried a fourth audio option, Madam Hearing Officer.
Ms. Gerson, we can't hear you at all. I'm sorry, Mr. Nasco. Microphone.
Very brief questioning, and I could be done within 10 minutes.
Really? All right, Ms. Gerson, I'm sorry we have to return to you in the morning. It got progressively worse. I'm sorry. Mr. Nasco, go ahead.
Oh, thank you very much. Madam Chair, members of the board, and Madam Hearing Officer, my name is Tom Nasco. I represent Growth Energy, and I'm going to do our best to make sure we're out of here before 45 days. I have a few questions today, if I may, for Dr. Murphy. Dr. Murphy, I know you spoke generally in your testimony about certain matters, including the indirect land use changes. I was curious about that concept. I think you talked about the land use values developed by the California Air Resources Board in 2014 or 2015. Is that correct?
Yeah, the work was done, I think, primarily in 2015. It's possible some of it was in 2014, and they were adopted into the rule in 2016.
And to your knowledge, is that the land use values being proposed for adoption in New Mexico?
I believe so, yes.
All right. Now, in the last 10 years, there's been certain refinements to models of land use values. Do I have that correct?
There are certainly a number of additional models that have been published and make claims to answer the question. Again, the EPA intermodal comparison report that I referenced covers a number of those.
Got it. And I think there's been additional data developed in the last 10 years that have caused this refinement and modification of certain models. Do I have that correct as well?
Yes, there's definitely been development. I would say that certainly on the lipid-based fuels, those are made from fats, oils, greases. I don't know if we're really starting to see much consolidation around numbers, though, and perhaps some of the other things on corn, maybe there was a bit of alignment around a certain range of possible outcomes.
And I'm particularly interested in the Argonne National Laboratory development of, I think it's called a carbon calculation for land use change, or the C Club is the acronym. Is that
C
correct?
Club, yes.
And you're familiar with that, right?
Yes.
All right. And that's a land use emission factor model that developed by Argonne. Is that right?
Yes. If memory serves, it uses the GTAP framework to look at sort of trade balances and flows, and the C Club element is emissions factors for the emissions because of the change in land use predicted by the GTAP model.
Yeah, so it uses different data inputs than the CARB model that you referenced earlier.
Yeah, CARB uses GTAP. I believe it might be an earlier version of GTAP, and then the AEZ or agroeconomic zone model for the land use change emission factors.
And the C Club model that Argonne National Laboratories developed, that was adopted by the federal government. Is that right?
Yes, I think there's some complexity there, but yes, it was in early versions of the 45Z tax credit. They had proposed to use that as one option. ILUC was eventually completely stricken from 45Z, but it has been in use in some cases. Yes,
and that more current model has also been adopted by other states, including Oregon, I believe. Is that correct?
Oregon uses, I believe it is a C Club projection for corn, but not for other biofuels.
Great. That's all I have. Thank you, Madam Hearing Officer. I appreciate it, Doctor. Thank you so much.
Thank you very much, Mr. Nasco. Let's see here. Is there anyone else present, for example, who has just a short question, the way Mr. Nasco just did? No? All right. Should we not optimize this last 15 minutes? If you have a question, you can leap in. That would. Any other board members have questions about following? I cannot hear you. Oh, I asked oh, dang it.
I asked if any board members could ask questions.
It's irregular to inject this way, but let's do it so that we can use this last 15 minutes.
I'm going to follow up on that line of questioning for Dr. Murphy. And I apologize, I wasn't quite prepared to jump into questions. So let me make sure I phrase this correctly. You talked about in your testimony and I apologize again if I mischaracterize this, but trading land use that was being used for food and now is growing fuel.
Yeah, so one example of this is historically the United States has been a big producer and exporter of soybeans, and soybeans are typically crushed into oil and meal. Over the last 5 years, we've seen a real major expansion of biofuel production using vegetable oil in the US. Soybean oil has been a major component of that. And so now we're seeing less soybean oil, both crushed soybean oil exported in its oil form, as well as fewer whole soybeans, which contain both the oil and the meal, being exported out of the U.S. And this is during a period where consumption of vegetable oil continues to grow as population and economic growth continue to drive that up. So we're seeing global consumption of this increase, but less of it is coming from the U.S. So unless it's materializing out of thin air, which the laws of physics kind of object to, somebody somewhere is growing additional vegetable oil. Now, not all of that additional production is going to be from clearing additional land. You can use better fertilizers, better forms of agricultural practices, better cultivars, specific types of seed. But to the extent that some of that increased production likely is coming from expanded agricultural area, the emissions associated with that expansion are there in part because of the expanded production of biofuels in the U.S.
Okay. Has there been any studies or have you looked at the impact of taking agricultural land out of food production and moving it into fuel production on the greater food demand in the U.S. or anything like that?
Yes, it is extremely complex. There is no way I can begin to do it justice in the 10 or so minutes we have left. But these are where we have a lot of very complex models where we are seeking to understand these dynamics and have better ways to predict impacts as we think about the policies that are going to affect these areas. It's further complicated by the fact that with every biofuel feedstock, it's not producing just the biofuel, but there's also co-products, right? So soybeans produce the oil and the meal goes into animal feed or other markets, corn ethanol. When corn goes into an ethanol facility, oil is also extracted. There's an animal feed product that comes out as well. So there's multiple kind of second order impacts as you see markets shift in complex ways. The basic laws of economics and supply and demand say if demand's going up, there's going to be some impact on price or availability. So far, global producers have largely been able to bring enough additional production online that we're not really seeing persistent long-term food shortages or major sort of increases in food prices that are predominantly attributed to this. But the environmental impacts and the emissions impacts, those do appear to be real, and they need to be considered when we think about how much of these fuels to use. Now, I want to be clear, this is not to say that all biofuels are going to be worse than petroleum or that they have no role in decarbonization. If you calibrate the amount you use appropriately, you have appropriate protections to minimize land use conversion where possible, they can certainly provide a scalable, meaningful amount of a fuel that is lower carbon than the petroleum we're trying to displace. But it is extremely complex to understand that. And like I said in my initial testimony, the models we have are not quite as well defined or as mature as we'd really like, given the complexity and the number of jurisdictions that are beginning to adopt more and more programs like this.
Okay, and I realized I was asking you a really big question there. As we look at this rule, and I realize we're in the very beginning of this hearing, I'm looking for a little bit of context because, as I understand through your previous testimony, that you didn't have the ability to run a model specifically for New Mexico, and in this state, we do face some challenges with water, with taking farmland out of production, with kind of switching some things around there to meet other needs in different parts of the state. And I am hoping that maybe somebody on the panel can offer some sort of insight or context to how these pieces kind of fit together. And if you can't at this time, that's okay. Or if you want to direct it to a different.
So one thing I would say about biofuels in general is that when you consider state level policies, you have to also consider the effect of federal policies, the renewable fuel standard, 45Z tax credits. Federal policies like the renewable fuel standard or the 45Z tax credits or the previous biodiesel blenders credit. And generally speaking, the environmental impacts that we're worried about are more tied to, at least the greenhouse gas impacts, are more tied to aggregate demand. You are absolutely right. There are local impacts on where specific crops are grown and whether water is available in a specific area. But at least from the greenhouse gas side, which is the impacts that my work focuses on, the federal policy has more to do with the aggregate amount of biofuel grown. What state policies do is they determine where they go, right? Which states receive most of that. And the state policies have also are generally thought to be more effective at encouraging biofuel producers to continually find ways to produce in more efficient ways. The federal policy, sort of the renewable fuel standard mainly, it creates basically buckets. Certain fuels go into the renewable bucket or the advanced bucket or the cellulosic bucket that has a threshold of greenhouse gas reductions. But once you're in there, there's not much incentive to keep getting cleaner and cleaner over time. Whereas policies like the CTFP provide that incentive. And so when you look at the maturation of biofuels in the US, we have seen significant improvement, incremental improvement in the efficiency and sort of a reduction in the greenhouse gas emissions and the carbon intensity of each fuel that is best explained by the effects of policies like the low carbon fuel standard, which has been in effect for 15 years now, and other policies like CTFP. So it is unlikely that any single state policy is going to provide so much impact that it's going to single-handedly drive, a massive expansion in aggregate production. Not impossible. That's why you have to adopt some basic precautions and do things like what California has done to sort of add an ILUC adjustment factor to the CI scores. But at least from an aggregate production level, it's unlikely that the state policy is going to sort of outweigh the impact of the federal policy.
Thank you for that. It was very informative. Last question, and I think we're right on time there. We focused a lot on biofuel production from crops. Is there another type of biofuel production that is leading or ahead of crops, such as algae production or anything like that?
So at the moment, there are some pathways for waste-based biofuel production. A lot of them are in the renewable diesel or biodiesel space, where you use things like used cooking oil or tallow. Generally speaking, if you have a waste, that's great. Making fuel out of it makes a lot of sense. There's just not enough used French fry oil or tallow to make a real dent in global demand for fuels like this. So the other thing is, for a lot of those wastes, it's not that they would have necessarily been landfilled in the past. They would have been used for some other lower value application. A lot of used cooking oil would have gone into animal feed, for example, and some of that might have to be replaced. So understanding those dynamics becomes important. There are opportunities to use for cellulosic fuels, where you're using opportunities for cellulosic fuels, where you're using the inedible parts of a plant. So, one common crop there's been a lot of investigation on is corn stover. So it's the leaves, the stalk, the stem, the cobs, everything that's left over after you grow corn, and take the kernels off and use that. Cellulosic fuel technology has struggled. There's still demonstration plants out there. It's still something people are working on. I think it is a challenge that people will eventually crack. Humans are generally good engineers and can solve technical challenges, but it has taken a while. and there have been a number of sort of false starts. You mentioned algae. Algae is another one where the technology has really struggled for a couple of reasons. It has to do with separating the useful parts of the algae from the water, both inside the cell and the water that it grows in, as well as if you're using algae that are either selectively bred or engineered to produce a lot of useful products for us, wild organisms can get into the same environment and outcompete them because they're not growing all this useful stuff for us. Again, these are technical challenges. I think humans will eventually solve them because, generally speaking, we are able to solve technical challenges like that. But it has been slow, and certainly, I would say, cellulosics are probably closer. We're seeing some limited deployments of cellulosics successfully. Corn kernel fiber, right? So corn ethanol plants will now recover the cellulose from the kernel that encompasses the corn. And they can increase yield a bit that way. That has been pretty successful so far. Hyzen, a Brazilian company, has recently commissioned the second sort of purpose-built cellulosic ethanol production facility using sugarcane bagasse. And the fact, sugarcane bagasse, it's the leftover leaves and stem and stuff after you process sugar or molasses out of sugarcane. And the fact that they built one and enjoyed it enough and to go for a second is a pretty big step that we have not yet seen in the cellulosic space. So I think there's opportunities. To be clear, with cellulosics, they're not zero carbon fuels. They're lower carbon than most sort of traditional crop-based biofuels. They're not zero, but they're certainly a big step that would also significantly expand the potential supply of biofuels into the market.
Thank you, Member Trujillo. Would you do me one favor, please? Spell bagasse?
Bagasse.
And cellulosic?
Cellulosic.
Thank you very much. We will end for the day and be back in this room at 9 a.m. Thank you all.